I want to amend the writ petition, my lord, and that's why I require 10 days time. Because there are some defects which are to be.
You want to amend the writ petition, why?
Because I have no challenge the validity of the report of the state level committee.
So if you have to challenge it, then why don't you withdraw with liberty to refile?
My lord, let me amend it, my lord.
This is a long process. Don't you think you will file an amendment application? This court will pass an order for amending, then you will file another writ petition for that purpose. Would it make any sense? Except delaying the process.
As your lordship may like.
You withdraw with liberty.
Yes. Let it.
Mr. O.P. Bhatti, the learned counsel, submits that during the pendency of the instant writ petition, there has been subsequent developments in as much as there is a report report made by the
State level
committee of
state level committee.
pertaining to what? There are many state level
Uh,
committees.
State level committee, my lord. Yes. Yes. Just a minute. The state level committee is there.
Or
Office of the Commissioner of Industry and Commerce
huh?
for grant of the subsidy, man.
No, the state level committee is of the particular department.
That is Office of Commissioner of Industry and Commerce. That is only
By a state level committee of the office of the
Commissioner of Industries and Commerce.
Commissioner of
Industries and Commerce.
Industry and Commerce. He therefore submits that he may be permitted to withdraw the instant writ petition without prejudice to the petitioner and refile it by bringing on record a challenge to the subsequent events. Taking into account the above, the writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner to assail the actions already impugned in the present writ petition as well as the subsequent actions.
Matu.
Interim orders, if any, stand vacated.
No interim order.
May I please, Lord? My Lord, item number 35, my Lord. We are going to file a reply, my Lord. Otherwise, our reply is ready, my Lord. Matter will be adjourned till next Monday, my Lord.
What?
Monday, my Lord.
For
filing a reply, my Lord. Against the affidavit in opposition, my Lord. Petitioner is from Porakbeli. He is coming today, my Lord, for swearing the affidavit, my Lord.
the council with the longest name. Let me tell you, in this court, this type of things doesn't happen. At the time of mentioning of the mentioning hours, if you don't ask for filing replies, that will be seen when the matter is taken up.
My Lord. And otherwise, I have some difficulty also, my Lord.
Tell me that you have some difficulties. Mr. A.H.M.R. Chaudhary, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation. List the matter of the 6 weeks. Next.
1 week, my Lord.
No, 6 weeks.
My, sorry, my Lord.
Difficulties
Then my
what?
Lord, I will remain present, my Lord.
You'll wait. Fantastic.
Slightly similar prayer, but my apologies for the defect because your lordships on the last occasion given me time till 7th of November to file my reply to the affidavit in opposition filed by Oil India. It's already sent, could not come on time. I'm only requesting if your lordships can give me a time at least for a week or so to refile that affidavit.
Which one?
This is my item number 61, which is.
I can't give you the time. You have to wait for that. And if you want, you have personal difficulties, matter goes for 6 weeks. Either 6 weeks.
I'll wait.
Mr. R.B. Phukon submits.
I'll wait.
Yes.
Wait.
May it please your lordship. I pray for listing a interlocutory application, lordship, for impeachment.
Next week.
My lord, seminar prayer for listing of a matter, my lord.
Or
This is for admission, my lord.
matter pertains to?
Matter relates to, my lord, here we have challenged the executive order in respect of compassionate appointment, my lord. In respect of compassionate appointment, there's an executive order has been issued by the administrative authority that we have challenged. And in that case, notice was issued, my lord. Thereafter, it was listed on 3rd of November, but it was not
You have
listed.
challenged an executive order
Yes, my lord.
passed by?
Passed by the, my lord, commissioner, my lord. Of,
How can I take up that matter?
my lord, this is in respect of all the departments, my lord, compassionate appointment.
Department, which department?
My lord, all the departments.
So therefore, how am I concerned? You
My
you
lord,
have to
my
go to
case
bench
is-
3.
Case is regarding, my case is bench 4 matter, my lord.
Challenging
So
a
in my case,
passionate
I have
appointment. matter-
In my case, I have challenged the
Are
executive.
you a
order.
Guwahati High Court employee?
No, my lord,
Oh, then go to bench 3.
bench 3.
May it please your lordship. Lordship, I beg to mention two writ petition for listing, lordship. Lordship, one pertains to a delimitation order issued without the consent of the Gao Panchayat, lordship, and another pertains to election of president of Gao Panchayat, lordship.
Let's have it when?
Lordship,
The fresh matters?
one is a fresh matter and the other one is a
Matters
2024.
we'll have it day after.
Lordship,
And the new other matter is
lordship, delimitation order, lordship, in violation of the Assam Panchayat.
delimitation. We'll have it after 1 week. After-
Lordship, in the new.
Give a date.
Please, your lordship, I beg to mention for calling an IA and as well as an additional affidavit in item number 36 and 54 of today's list.
What IA business?
Lordship, IA in item number 36 has been filed for implement of other bidders, your lordship. And item number 54, additional affidavit is filed, your lordship. Certain document has been annexed. your
34.
lordship. 54, supplementary list.
But I can't permit bringing in an IA today. We'll see when the matter reaches.
Additional affidavit makes deeply obliged.
May it please your lordship, I beg to mention item number 29, my lord. My lord, the respondent have filed an affidavit in opposition last week on Wednesday, Thursday, my lord. My lord, 4 weeks time may be granted to me to file a reply to the affidavit in opposition, my lord.
You came just now to the court?
My lord,
Okay. I don't allow this type of prayer at a motion.
apologies,
bench.
my lord, I'll just pray the same when the matter goes. Much obliged.
Item 31, fixed at 10:30 AM, personal appearance through BC.
Where is the, because the additional chief secretary.
My lord, the mission director is going to join, my lord.
But I didn't ask the mission director. He's the mission director, the commissioner secretary to the government of Assam,
Mission director.
PhD department.
Yes, ma'am.
Yes.
Good morning, Honorable Justice.
Yes, Mr. Karthik, the only thing why I've asked you to be present in the court, what I've noticed out here, there are many writ petitions wherein after 10 years, 12 years, 13 years, 14 years, 15 years, not only in your department, then also in the PWD department, which is happening, is that the executive office engineer from nowhere gives a liability statement.
Right.
Whether he looks into those liability statement, whether in fact it happens or not, nothing is there. in this particular case, if your standing counsel must have apprised you
Ye-
about this
yes.
thing, what has happened here? These are matters of 2011-12.
Yes,
Then one fine morning, he gives a liability statement in 2021 or 22. Then the petitioner comes up and moves another writ petition in 2025. Now, the period of limitation normally is 3 years.
right. Right, my lord.
If there is anything which is correspondences going on, these are different aspects of the matters where they are admitting to the liabilities. Now, if you earlier also see the judgment of Tamsir Ali also, the full bench also considered that these liability statements are to be given normally by the chief engineer level officers. But on account of these executive engineers giving these type of liability statements, that too without any dates or anything to that effect, or
Right.
if any date, and these are not also endorsed to the higher officers,
Yeah,
it creates a lot of problem. Now, tomorrow I pass a direction out here. Okay, you make a verify and make the payment. It is next to impossible for the officers also to verify and pay. Make
absolutely.
the verification. And at
Absolutely.
the end of the day, it results in contempt applications being filed. So I would only urge upon you to take care of, as you are holding a high office, to look into the department that such things do not normally happen.
Right.
Yes, it is a person who has been deprived of his dues, and it has been regularly he is representing, and something has been happening out there, and all the departments are looking into it. The chief engineer also writes to the government, and the government thereupon says that, okay, there are certain formalities. These are different aspects of the matter.
Understood.
But here, one liability statement is being given from nowhere after 10, 12 years, and thereupon these things happen. And this is not the only case. In most of the cases we find in the PHE department as well as also in the PWD department, this is a habitual thing which is being happening on the part of the executive engineers. That is the only reason I wanted that this aspect be brought to the notice of a high office, so that you can very well take up the aspect with the others. Because every time I keep on dismissing, but it doesn't go to the officer's concern
Yes.
that this is what is actually happening in the court. And I in this court, I take a strict view on this aspect. But otherwise, in some courts, there are directions being passed for pay and make the verification. And I also understand. You may be having recently all things computerized, but in 2010, 11, these were not computerized. And you will be also surprised to take note of. These are amounts which are very small amount. It otherwise looks very insignificant. But you are aware that the drops of water make a sea. So this is what is happening actually.
Thank you so much, my lord. I think you've hit the nail on its head. I mean, for us also, some of these things come at as a surprise. We are also at the last moment. We didn't, I mean, like you rightly mentioned, something which has happened almost 15 years or claimed to have happened almost 15 years. Unfortunately, since things were not digitized at that point in time, some of the records are also very difficult to retrieve. And more often than not, once a court passes an order, we are sort of forced to pay up without necessarily verifying or in a position to even verify some of these things. So I totally am very grateful that you brought this matter to my notice. We will ensure in this particular case also, though it was only passed about 10 days back, what we quickly gathered is there doesn't seem to be, I mean, the engineer concerned who had signed, allegedly signed on the completion certificate has since retired, and we couldn't find any documentary evidence even in our records to say this work has been executed or this engineer has signed such a record. So thanks a lot. We'll make sure that we put in systems and, like you rightly mentioned, go to the root cause to ensure that such an
And these work completion certificates are given out here, no dates, after 10, 12, 13 years.
Yeah.
How is it possible?
And in this specific case, my lord, we don't even have a record on our files. I mean, the current engineer who's verified the records, he doesn't even see this documents on the official files. So we've already called for an explanation from the then engineer who's since retired. to understand whether these are documents which are even genuine, or has there been any forgery or any such thing in this particular case, because we're not able to trace the true copies from our office as well.
Yes,
So,
yes, definitely.
so
And more particularly, these are works done in work orders issued in 2011, 12, work completion certificate, no dates. Then in 2021, there is a certificate being given, and 2025, the petitioner approaches this court. So you can't even trace out which officer
Yeah.
it is, because the officer's nothing is being given. What
Yeah.
is his name? No credentials is also given.
we've only gone by who used to hold office around that time.
Hmm.
And then we've, so that's how we've gone ahead. I mean, in 2021, whoever was the executive engineer is whom we've gone asked for an explanation. But for us to trace back on records, we don't even find a copy of these. I mean, the typical government process would be, if you're issuing completion certificate, you would keep a true copy within your office files as well. And these are almost 7 different projects, so-called projects. So each of them would have 7 different files. So even if there was something missing in one file, it's unlikely that it'll miss in all 7. And the initial feedback that I've got from my team is that we've not been able to trace in either of the 7. So like you rightly said, there seems to be something more than what meets the eye.
Yes.
So we will
And,
certainly
and
go.
there is another way out, is asking for some inquiry. But this, how many inquiries can happen?
Yes, my lord. Yes.
It means it will also be taking away the time of the CID or the police, who have
Absolutely.
other better things to do.
Absolutely.
So
Absolutely.
therefore, if your certain instructions are given from your end, from your department, then not to issue this type of certificate, then it will arrested at the root.
Absolutely, absolutely. We will certainly take this as a, as a case or a case study or as an example, and I will make sure that, I mean, due process is followed. And like you rightly said, where there have been commitments by the state where execution has happened, and for whatever reason we have not been able to pay the contractors, those are obviously a different ball game altogether, and those are where people need to be compensated. But in the garb of that, those where suspicious work has been executed or not executed, those they should not get a opportunity to use this goodwill of the court or the government to sort of mislead either of us. So thank you so much, my lord.
Yes.
Thank you.
Your presence is excused now.
Thank you so much.
The threshold that, my lord, that particular work order and like this, and no deal was submitted by the petitioner. Only the office record is available. The running deal, my lord, is here by the office, my lord, without signature of the contractor and executive engineer at that time. The person who issued the work order completion certificate is no longer in service. Before retirement, he, whatever the, my lord, instruction is there, like instruction. The person issued the certificate to the, my lord. There is no office record available. We have filed a affidavit, start the copy.
No, I knew it from this. That is why I am catching hold of this type of matter. And this seems to be a system which is now being taken up, and they don't go for huge amounts. The amounts are just 2 lakhs, 3 lakhs, 1 lakh, 1,25,000. So why a person remembers about this 1,25,000 pending after 12 years or 15 years? There must be a good reason for that.
That case also, my lord, there is a specific order of requirement of a particular brand is required to be supplied. In the work order, it has not made any statement in the requisition that he can supply that particular brand of the, my lord, that equipment, my lord. So we have filed the affidavit, my lord. Let's take it up in the Thursday or like that.
Okay, we'll take it, give him 1 week's time to reply. And then we dismiss his petition with exemplary cost, and so that it becomes known to all people that this type of things will result in this.
My lord, just 1 minute. 18/8/2025, that was written by the chief engineer to the secretary, my lord. Your lordship may kindly produce, my lord. Just this letter. And I will also bring it on in my reply affidavit also. Your lordship may kindly produce this. My lord may dismiss my petition, but Your Lordship may kindly peruse this.
But why we don't find any details of these letters which have been mentioned in your petition?
My lord, that is a departmental correspondence, my lord.
No, 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 no.
I have
No, no,
whatever
Mr.
documents with the petitioner, my
see,
lord, he submitted.
Here, it appears to be that this work might be separate from what you have done. Because you see, you have received a letter of 19/4/2025 regarding pending liabilities in favor of Alampuriya Enterprise under Bukakhat Division on so and so. This is 19/4/2025. Where is your document for 19/4/2025?
Nineteen six, 2025, my lord.
19/6, no, in 19/4/2025.
Or nine.
Mr. Ayalam, if
Yes.
this, you are you are a person who otherwise has a lot of contracts with water resource department or the PHE department. Because these happens to be under the NDRWP.
My lord, National Rural Drinking Water Program, my lord.
Now, these are contracts which have been awarded in terms with under that
2012, my lord.
2012.
My lord.
Yes.
That is 19, my lord, 19, 20, 21. And 23, my lord. Page 23 also, my lord.
You have filed an affidavit, no, Mr. Sir?
Yes, my lord.
You want to file?
We will also find it.
You file an affidavit, huh? We'll take up this matter in a very serious manner. Although I take all matters in a serious manner, but please. You file your reply.
My lord.
Pursuant to the order passed by this court, the Commissioner and Special Secretary to the Government of Assam, PHE Department, come Mission Director, Jal Jeevan Mission, Dispur, namely Sri So-and-so, had appeared before this court. It is also seen, Mr. J. Sutia, the learned counsel, standing counsel of the Karbi Anglong Autonomous Council, submits that an affidavit in opposition has also been filed in the instant with petition, and copies thereof have also been forwarded to. A copy thereof have also been provided to Mr. I. Alam, the learned counsel, who appears on behalf of the writ petitioner. Mr. I. Alam submits that he would submit a reply. Mr. I. Botakur, the learned counsel, standing counsel of the PHA department, also submits that the PHA department would like to bring on record their stand by filing the affidavits. List the matter on 3rd of December 2025. In the meantime, both the PHA department as well as the petitioner is given the liberty to bring on record their stand by filing affidavit in opposition as well as affidavit in reply respectively on or before 27th of November 2025. You have a look at this document.
Yes, we have
I
been
have
given a
a-
copy, man.
I have given them a copy, my lord. Obliged.
Okay. Page 26 is the order of the court, my lord. Interim order passed by this honorable court.
Page
26, my lord. Impugned order, my lord, two impugned orders where they are recovering notices, these were stayed, my lord, by this interim order. Then, my lord, they passed this order, page 28, my lord.
when did
This
they
amount
offer?
has been recovered from another contract, my lord. Another contract, the NDC was given, they are going to release the money, but while releasing the money, this 29,99,000 has been recovered. First deduction, we have no grievance, my lord. Second one is regarding this interim order, my lord, 29,99,000 something. This is the same matter, my lord. It has a long litigation process, whether the FCI can recover the amount after the contract has been closed. Your lordship passed an order recently, my lord. And that is also been affirmed by division bench and the appeal has been dismissed. The same point of law, my lord.
Now then, they have recovered
This recovery has been made, my lord.
on 1/3/2025.
My lord. My lord, initially they said, my lord, we are pursuing the matter. Initially they said it was a mistake, they will correct it, my lord. At a higher level. And we're waiting for that, my lord. It appears then they're not doing anything, my lord. They refer
Now,
to,
this writ petition is disposed of 6745.
no, this is the interim, no, it's pending. They are, first time it was listed, they have not filed any response also. This is the interim order, my lord. They have referred to this, my lord. Money which they
That
deduct
they have refunded you the
Madam.
security amount.
after the litigation up Supreme Court level, my lord. Now, after holding GRC, this GRC order has been passed, the demand notice has been passed, which have been stayed by this honorable
But
court.
here the amount is different.
My lord,
Amount is 21,66,907
with interest,
in the page 26.
my lord, yes.
And what has been withheld is
No,
29,99,903.
that Yes, my lord. Principal amount was 20, my lord, I'm coming. 21,66,000 is the principal amount. Along with that, court directed to pay interest. That came around 8 lakh something. The total 29,99,903 was deducted. That was the principal amount, my lord. The interest part has not been mentioned. In the GRC order, it is mentioned, my lord. Page 24, that recovery order, my lord. Demand notice.
Issue notice making it returnable on 15th of December 2025. Steps be taken upon the respondent numbers 1 and 2 by speech. The petitioner is also given the liberty to take steps by way of the stay rooted to the registry of the spot and file an affidavit of service on or before the next day. The petitioner herein is agreeing. And petitioner herein have filed the instant contempt proceedings, alleging willful and deliberate violation to the order passed by this court dated 17/12/2024, whereby this court specifically state the impugned order dated 8/8/2024 issued by the GRC and the demand notice dated 3/12/2024 issued by the Assistant General Manager contract for General Manager region till the next returnable date. What has happened to this matter?
Which matter?
This writ petition?
This petition is pending.
Was the interim order extended?
No, it has not been listed again, my lord. It was for till returnable date, my lord. Chapter 4, it has not been listed till date, my lord. They have not filed any response also, my lord.
17/12/2000 passing WPC number 6745/2024. It is the case of the petitioner that despite the said order having been already, and in spite of the said order dated 17/12/2024, the respondent herein have deducted the said amount of rupees 29,99,903 from the ongoing contract, have deducted an amount from other dues of the petitioner.
From another contract, my lord. By closing the contract, it is mentioned, my lord. Third line, second
From
line.
other dues.
Yes.
Other dues payable to the petitioner.
This,
How did they recover?
this amount has been recovered from while closing another contract.
That is what I am saying. From other dues payable to the petitioner.
Yes, ma'am. Yes.
Then other dues payable to the petitioner on account of the writ petition being WPC number 6745/2024 being pending. So the respondents herein are directed to bring on record their stand by filing the affidavit on or before 8th of December, 10th of December 2025.
Item 2,
I'll list this matter along with so and so, that's 6745 on the next.
May I please, your lordship? My lord petitioner, before your lordship is an adjusted, my lord president of my lord of premises, my lord, wherein an IMFL onshore has been, my lord, allowed to shift by the deputy commissioner, my lord, without making any inquiry, my lord, without taking any NOC from the local public, my lord. In this regard, my lord, that the concerned, the president of the concerned, my lord, panchayat, from whether, my lord, as per the mandate of the Excise Act 2016, my lord, NOC is required to be obtained. He has also, my lord, submitted and, my lord, objection petitions. The other, my lord, the people, localities were submitted, my lord. In spite of that, my lord, that the shifting order was not cancelled. Now, my lord, they are not, instead of disposing the grievances of the petitioner, they are contemplating to, my lord, shift the shop, my lord. My lord will find this. So, may kindly turn to page 31, my lord, the details of the complaint that has been submitted by the petitioner, the president of the Panchayat, and my lord, other. Page 31, my lord. Page 31, my lord. Page 31, my lord, in the reference column, my lord, the details of the complaint that has been the superintendent of excise Borkota has forwarded. That all those complaints to the inspector of excise, my lord.
There is no wine shop in between.
My lord, there is already, it's in my lord, village area, my lord, under Panchayat. There was there is a existing wine shop is there, my lord. It's 15 meter away from this, my lord. Those, my lord, that from that side wherein the, my lord, newly, my lord, it has been, my lord, to the, my lord, places where the, my lord, wine shop has been allowed
I'm
to shift
asking
it.
you whether there is a wine shop
My lord,
already in existence.
my lord, yes,
Have you raised a complaint?
my lord, my lord.
Have you raised a complaint against the existing wine shop, another wine shop?
Existing is, my lord, just, my lord, 15 feet, my lord, perhaps 15 meter away from the petitioner's place, my lord.
And this one?
This one, my lord, 15 meters distance,
You are complaining about the wine shop belonging to somebody.
my lord.
I understand.
Well.
But is there any other wine shop in existence in that area within 75 meters?
Yes, my lord, there is a wine shop is there. My lord, at that moment of time, it was, my lord, old one, my lord. At that moment of time, whether they have, my lord, lodged any complaint or not, that
But
is
why
I'm not aware.
have you not lodged that complaint against that wine shop?
My lord, it was, my lord, perhaps, my lord, 5 or 6 years back, that wine shop was established, my lord.
So what?
But
you
at
have
that
a-
moment of time, perhaps
You
this,
have no problem with that wine shop, but you have a problem with this wine shop. What are your bona fides for that?
no, my lord, I'm not aware, my lord, whether at that moment of time where that, my lord, the earlier that wine shop was established, any complaint has been lost or not, my lord.
Because
In-
earlier the distance was much more. Now the distance has been reduced to 75 meters.
My lord, my lord, my lord
So
is correct.
therefore, why you did not lodge any complaint earlier?
No, my lord, perhaps they may lost, my lord, at that moment of time. But at that, my lord, I'm not aware whether they have lodged any complaint at that moment of
But
when.
was it so bona fide on your part that you have allowed one wine shop to remain, the other wine shop is not there?
My lord,
You have a problem with this wine shop, but not that wine shop?
my lord, maybe the problem may be there, my lord. My lord is correct, but
Or is
at
it-
that moment
is
of
it
time,
that you have very close affiliation with the other wine shop, which is running?
no, my lord, that moment of time, maybe I'm not aware, but presently,
Now, I'm asking you, do you have a very close relation with the owner of the other wine shop?
no, my lord,
Because another wine shop comes in, therefore the business would go.
no, my lord.
It
But
seems to be.
yes, my lord is correct, but here in my lord,
I
the
am
only,
correct, but the
my lord
fact
is correct.
remains.
My lord is correct, but the
You
complaint
are
is
saying-
not only lost by me, my lord, by the president of the, my lord, concerned Panchayat himself and other, my lord, public.
Understood, you have a problem with that wine. shop.
My-
I would have understood you don't want a wine shop nearby.
Yes, my lord is correct.
Very good. You don't want the wine shop nearby, you ask,
Mm.
all wine shops should be removed.
If my lord, if required, I
But
will,
why should you only be pinpointing one wine shop?
if required, my lord,
And for
will-
how many years you have been residing there?
my lord, since
For
my
how
lord,
many years you have been residing in
my lord,
that
since
area?
the, my lord, days of my ancestors, my lord, since the days of my ancestors, my
And
lord,
what is your age there?
my lord, age, perhaps, my lord, 33 is 33, perhaps, my lord.
So now you don't like any wine shop coming up nearby.
Well, this is sticking with my boundaries, and so far, my lord, that, my lord, that wherein the, my lord, newly, my lord, shifted wine shop is allowed to shift it, my lord. Just my house is, my lord, sticking with the boundaries of that premises, wherein, my lord, just 2 to 3 fence, 3 feet difference. And my lord, with my, my lord, with,
Where is your statement that it is next?
and
to
I'm
your-
saying, my lord, adjacent, my lord, adjacent plate.
Where?
Plot,
Where is it? Next means you have to come within 75 meters.
my lord.
Do you come?
No, I'm adjusting, my lord. Petitioner, the peoples, and then this. My lord, on para 2, my lord. Premises, the adjusting to the premises of the respondent number 10, my lord.
Where?
On para number 2, my lord. Of page 5, my lord. Page 5.
5.
5, my lord.
No. Your objections which you have filed.
My lord, in my objection.
I so and so permanent, it has come to my knowledge that one LT wine shop located at a plot of law Bina Muzumdar land is being shifted and prepared for operation in a new location near my plot of land. The said area is primarily a residential area with schools, colleges, so and so. The opening of a wine shop in such a vicinity will cause serious inconvenience. As an adjacent Kolkata, I strongly oppose the establishment of this wine shop on this location. Proposal has already created concern among local residents and the here. So this is given on 9/10/2025.
My lord, 19 to 10. My lord, herein, my lord, what happened, my lord?
And then
My lord, thereafter, my lord, the shifting order was.
no objection is given. This is to certify that so and so has no objection to the IMFL launch and OPR as per application submitted by Baby Taluka. Is a resident of here. After reviewing the application and conducting the necessary check, the council has no objection in the year. So Gaon Panchayat has given a no objection.
My lord, that, may I, my lord, clarify that aspect, my lord? May I clarify that aspect, my lord? My lord, there is a notification, my lord, issued by this, my lord, governor, wherein, my lord, that on my lord, 19th of October 2024, my lord, by issuance of this notification, my lord, the jurisdiction of the block has been, my lord, changed. My lord, there are now some, my lord, there is some delimitation process. And thereafter, my lord, that the 47 number, my lord, that the Kolabanga Gaon Panchayat, my lord, has, my lord, become 12 number Kolabanga Gaon Panchayat, my lord. And that moment of time, my lord, 47 Kolabanga Gaon Panchayat was not existing, my lord, and there was no, my lord, body. At that moment, my lord, there was no elected body, neither the my lord, president or my lord, any members, because my lord, after expiry of the 5 years, 10 years, my lord, it was sitting there. My lord, only, my lord, thereafter, at that moment.
Issue notice making it returnable on 21st of January 2026. Who appears for here? Excise?
JP Borua on behalf of K. Sekia for respondent number 1, 2, 3, and 4. JP Borua.
For?
Excise for KB, Korobi Sekia, K. Sekia.
For?
Excise Department.
Your Excise Council?
On behalf of.
K.
Sekia.
A. Setia.
K. Sekia.
K. Setia.
Yes, Your Lordship.
Who is K. Setia?
Korobi Sekia.
She's also Excise.
Yes, Your Lordship.
I've never seen her.
Standing counsel at that
position. Right, get hold of our Excise Council. Mr. R.R. Gogoi accepts notice on behalf of respondent numbers 1 to 5. Mr. MCT accept notice on respondent number 4. Aruyang 1 to 5. Mr. N. Borai accepts notice for 6, 7, and 8. As regards the respondent number 9, step 9 and 10, steps be taken by way of speed post. Extra copies of the requisition be served upon the standing councils who represents the respondent number 1 to 8 within 2 days. As regards the respondent number 9 and 10, steps be taken by way of speed post and within 3 days. The case of the petitioner hearing is that the respondent number 9 have been awarded, have been granted the permission of shifting,
Shifting, madam.
Shifting IMFL
Ops of, madam.
of license shop to a nearby location of the petitioner without following the mandate of rule,
The Assam Excise, my lord.
rule,
The Assam Excise Rule 2016, my lord.
rule
Rule
That most probably two,
298,
290 or 280.
289 or 298?
Yes,
295,
I'll find, I'll have to.
298 or 295? 289.
289.
No, 289.
My lord, 289.
Mr. Counsel, you have come
I-
prepared without
I
knowing what
apologize,
is
my
the law about this thing. It is not that.
289 is there, my lord. 289. 294 is there. 294A.
294, it
Without-
comes at 294A, Lordship.
Without complying with the mandate of Rule 294 and 294A of the Assam Excise Rules 2016. Full stop. The respondents herein are directed to bring on record their stand by filing the affidavits on or before. Okay, by stay here, it's good. 21st, 21st, on or before 19th of January 2025.
Item 3.
Obliged.
Maybe, His Lordship. In this case, your Lordship's matter relates to non-payment of contractual bill amount, your Lordships, 2,62,1,601, your Lordships. In the year of 2004, completion certificate, if you find your Lordship 21 page. Completion of work 21. 8 number, date of completion 29/7/2020.
Where? Date of completion?
21 page. Page number 21. 29/7/2024. 8 number, date of completion.
Date of completion 29/7/2014.
14, yes, 14, your Lordships.
Then
So the, yet not the contractual bill amount not paid, your Lordships, by the concerned authority, your Lordships.
then
So, and in the, and thereafter, they have filed one representation, annexure 10. Page number 30.
how much you are entitled to?
2,61,601 rupees.
So there is a financial sanction also given.
Yes, your Lordship.
Then also you have not got the money.
Not yet. And similar situated contractor has also approached before this honorable court, and accordingly, this honorable court disposed this matter, and the direction was given within 45 days, and accordingly, that amount was found, your Lordship. That page number 27, similar situated contractor was approached. I am also the same contractor.
You are the same contractor.
Another contractor was same, your Lordship.
But tell me, he approached in 2020. You are approaching after 5 years. Why?
Lordship, again you find page number 29. I'm also representation was filed, Honorable Minister Health and Family Welfare, that 2015, annexure 9.
No, because after that,
Yes,
the financial sanction is given on 4/8/2015.
yes.
Thereafter, why after 10 years?
After verbally issuing that, after verbal issuing your Lordship,
So you do one thing, you approach after another 10 years?
Lordship,
No, they're giving you.
yes,
You could wait for 10 years, so wait for another 10 years.
Lordship. Similar order, your Lordships, 27, page 8 number para.
No, this can't happen like this, Mr. Counsel.
Yes.
Hello, I dismiss it.
I withdraw, Your Lordship.
No,
Withdraw with liberty.
I'll give you the dismissing with a liberty to go to the civil court.
Also, I will withdraw with liberty, face Your Lordship.
Huh?
Withdraw with liberty, I will face Your Lordship.
Face what?
Lordship,
To come here.
in the meantime, I will approach Your Lordships and file.
You have already approached in 2015, 25. There's a financial sanction given to the accountant general for payment of this 2,61,000. Why the payment has not been made?
That I cannot say now, Manoj, but
Can you come to page 22?
yes, I have seen it.
If there's a financial sanction given, then that would be the accountant general of this work.
That's
Then makes no sense why the payment has not been made.
You have to seek the inspection, or give it all notices.
This direction is from the Health and Family Welfare Department.
Yes,
The
otherwise, we
only thing is whether you have made the payment or not, that is the only question.
Yeah.
There is no quarrel with the fact that he is entitled to them.
that part completion certificate is there. Well,
Because
only
from
thing
this
was
particular document, annexure to page 22, it appears that there is a financial sanction we've been granted. And he must have received the 338.
Yes.
No,
338
338 is another book.
And another contractor.
Okay, for you it is this much, na?
There is the earlier reputation, man. Page 20. That amount pertains to another WBC 600 2020. But my lord, the proper necessary parties are not there in the reputation. It should be the director of medical education, my lord, as well as the
No,
proper-
and he is writing letters to executive engineer PWD. How will it help you? Tell me. You should have written the letters to this director of health and
or director of medical education. It's GMCH, my lord.
health and family welfare is there.
Now it is, my lord, 2025. Now, my lord, the nomenclature has changed.
What is the
It
name?
will be, my lord, medical education and research department. Health and family welfare.
And you should submit all these things to proper person. You are writing it to executive engineer PWD colleges. How will it help? Financial sanction given, everything given. Now director health and family not there.
No, director of health and family welfare is there, but my lord, for medical education is the director of medical education. Separate directorate is there. It's medical
No,
college,
DMT is
GMCH.
being given to by joint secretary to the government of Assam, health and family welfare department.
No, lordship will see down below, copy marked to director of medical education Assam, serial number 4. Others also, my lord, all medical colleges under the director of medical education.
This is what work did he do?
It is GMCH, madam.
Huh?
Some renovation work in GMCH.
For 2 lakh for renovation and upgradation of steps for medical staff quarter.
What a medical college and hospital.
No.
Very correct, very good, that's one more.
Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi, the learned counsel who learned additional advocate general, as well as the standing counsel of the Health and Family Welfare Department and the PWD Department. PWD Department and the Finance. Heard as well as Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of all the departments who have been arrayed as parties to the instant proceedings. The petitioner herein is aggrieved by the non-payment of an amount of rupees 2,61,000 601 to which the petitioner claims to be entitled to on the basis of the works carried out by the petitioner pursuant to a work order issued on 30/6/2014. The materials on record show that the petitioner completed the work on 29/7/2014. And there is also a financial sanction being granted by the Government of Assam Health and Family Welfare Department for payment of the amount of rupees 2,61,601 to the petitioner. However, the said payment was not made to the petitioner. And as such, the petitioner has approached this court by filing the writ petition. The record reveals that the petitioner, pursuant to the completion as well as the financial sanctions so granted, have not approached the proper authority as have been submitted by Mr. B. Gokul, the learned Additional Advocate General, Assam, wherein, inasmuch as the authority to whom the petitioner ought to have approached is the Director of Medical Education, Assam, isn't it?
Yes.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition and submit a representation to the Director of Medical Education, Assam. On the basis of the materials on record, so taking into account the above, the instant writ petition stands closed. Liberty, however, is given to the petitioner to submit representation to the Director of Medical Education, Assam, for releasing the amount of rupees 261,601 to the petitioner. It is observed that if the such Mr. So-and-so appearing on behalf of the petitioner submits that the petitioner would do so within a period of 30 days. Taking into account the above, the writ petition stands closed.
Right, Your Lordship.
Oh,
It does not be. Does not be so.
Yes, please, Your Lordship. Your Lordship, this matter is related to the retail outlet petrol pump of Hindustan Petroleum, Your Lordship, within the village Mazgaon, Your Lordship. And Lordship, as per advertisement dated 28/6/2023, the specific location for the Mazgaon, this advertisement was published, and accordingly the private respondent number 7 applied, and he has selected for the village of Mazgaon to establish the outlet, Your Lordship. But I am also selected for the village of Kota for outlet of Indian Oil Corporation, Your Lordship. But now what happened? This private respondent number 7, by violating the terms and condition of the
National Highway.
It's a rural.
selection brochure, Your Honor. No, it is a rural outlet petrol pump, Your Honor.
So what is the violation he has done?
The violation he has done, the selection is for the village of Mazgaon. But instead of that, he has now installing that petrol pump in the village of Kota, Your Lordship. And I am also selected for a petrol pump in Pata, another company, that is Indian Oil Corporation. In front of my petrol pump, he is now installing his petrol pump by manipulating the land record. His selection, I have no any objection. His selection for the place of Masgaon, Your Honor. And so far as the notice inviting by the company is the page 24, it is clearly shown that the advertisement under serial number 176, that is for the place within the place Masgaon.
So respondent number 7 has been allotted a contract, selected for a petrol pump at
Within the place Masgaon.
Mazda. Where is that here?
That selection, that is annexure 4, Your Honor, page 113.
No, page 2, annexure 2, where is that document? Then? Borpeta, rural. And his petrol pump is opposite yours.
Yes, Lordship. Lordship, I have selected for the village of Pota, and accordingly, my work is also going on. But now, surprisingly, this respondent number 7, he selected for the village of Masgaon, but instead of that, he is trying to install their petrol pump in the village of Pota in front of my petrol pump.
How, go file civil suit? How do I know?
Lordship, I have several.
Petrol over Mazda or where? How do I know?
No, it is a clear violation of the selection procedure of 2023 as published by the Hindustan Petroleum in their website. I have entered clause 4, subclause 6A and O is violated. Yes, Your Lordship, page 25, Your Lordship. And
Which clause you are
relevant,
referring to, Mr. Counsel? Which clause are you referring to?
clause 6, clause 4, subclause 6, 6A and O, Your Lordship.
6?
Clause 4, that is page 28, Your Lordship.
Where?
Clause 4 is the eligibility criteria for individual application, Your Lordship. And kindly come to the page 29. That is under subclause 6, that is land, applicable for the category. That group 1, the applicant having suitable features of land in the advertised location. And advertised location is the Masgaon, within the place Masgaon, Your Lordship. Area either by way of ownership, long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC, Your Lordship.
Oh, why have you written to your Indian Oil Corporation or not?
No, I have several representation made before the respondent number 2, that is Hindustan Petroleum, and also that is, Your Lordship, is 127. The regional manager Hindustan Petroleum Corporation Limited, I have made my complaint.
This is very difficult. Within Mazgaon village, Borpeta. So this is within Mazgaon village.
Within Masgaon place.
And where is your location?
My petrol pump selected, I am selected for the Blessed Pota.
Where is that?
That is another.
Where is that? Where is that document?
That document I have to annex here. That is page 119, Your Lordship. This letter was issued by the Indian Oil Corporation to the circle officer regarding clarification required for a plot of land selected for setting up for a petrol pump at Blessed Pota under Sharupata Revenue Circle.
Mr. Counsel, where is your thing that you have been given at that particular place? Some other village. Where is your letter of intent?
No, my petrol pump, not under the, Hindustan Petroleum, that is under
The
the,
council, your locus you are trying to bring is on the basis of you have been awarded a retail outlet somewhere. Because you are not a person who have participated in the said pursuant to the
no, I am
advertisement
not-
of HPCL. So therefore, your locus is on the basis of some retail outlet of yours. Where is it?
no, Lordship, that, I have selected for, Indian Oil, Lordship. That is another part, but this private customer number 7, he has, selected for the place of Mazgaon. Instead of that, he has now tried to installing their petrol pump in the village of Kota.
So how are you
I-
aggrieved?
Lordship, I will be suffered.
How?
And that petrol pump, that is also violation of their,
Forget about their
selection process.
violation, whatever their violation, how are you aggrieved?
Yes, Lordship, that, this is the rural petrol, outlet, Your Lordship, and in front of my pump, he has installing that pump, that
So
I will be.
therefore, I am asking you, where is the document that you have a pump there?
No, I am also newly selected. They are also newly selected, Your Honor. This is the,
Mr.
here it is mentioned, Your
Mr.
Lordship,
Bhattakur,
with reference to
explain
the
it to
above
him what
mentioned
I
letter
have
dated
said.
21 March
Yes,
2025.
explain it to in our native language.
Selection point এটার কোন আছে এখানে করান হেল্প করা নাই ইউজ করা না that letter I was not, exhibit here, NS here.
You are affected because you have a retail outlet. But how do I know that you have a retail outlet?
No, Lordship, I have also selected for retail outlet, and
How
regarding
do I
that,
know that you have a retail outlet there?
here in this letter, it is clearly shown that, Navazal district,
Where is
First,
the,
okay,
where
may I
is the
read- may I
letter by
read it?
which you have been appointed as a given the retail outlet for that particular location? Where is it?
so I am allowed to, file a, reasoned, affidavit here.
Counsel appearing on behalf of the petitioner submits that he will need some time to bring on record the document by which would show that the petitioner hearing have been allocated a retail outlet in a neighborhood wherein the private respondent have been granted a retail, issued a letter, have been granted a settlement of a retail outlet by the HPCL. How much time?
1 week.
Taking into account the above, list this matter again on 19th of November 2025. In the meantime, liberty given to file the additional affidavit on or before 17th of November.
Bless you.
Item 5.
Wait, please, Your Lordship. Matter relates to non-payment of dues for higher charge basis. His car was taken on rent by the respondent authority. Initially, they made some payment, but the balance amount remained unpaid. The car has in the meantime been released by the respondent authority. We have also filed a representation, but they are not.
Who appear? I appear for. No, Mr. B. Gogoi, you don't appear. Ask anybody of them to appear.
Finance.
No, finance is there. Okay, finance you appear. Otherwise, all others let them.
But
Mr. B. Gogoi for so and so remaining MZT. Issue a notice returnable on 21st of January, no, it will be on 6th of February 2026, affidavit to be filed by 29th of January.
Pendency may not be a bar to
Absolutely no. You will get the money
Obliged.
after that.
Six,
সেইটোৱেই আমাৰ non-payment of এই তাত মই এইটো চশমাটো চাফা কৰিব দিম চশমাটো আৰু লেতেৰাই হৈ গৈছে এই প্ৰব্লেমটো কি তাক মাতকচোন
May I please your lordship? Lordship,
Yeah.
this matter relates to not releasing the vehicle on vehicle seized and kept under custody with effect of 1/2/2024. It was seized because the driver had loaded some illegal beetle nuts, which the owner was not aware, and it's still on custody. And he has given a representation to the Assistant Commissioner Custom that they had given us notice that he can obtain the vehicle with 30% of that, and he has asked them to reduce by 10%, but still nothing has been done by the custom authorities.
So the vehicle is in whose possession?
Lordship,
Who has the possession of the vehicle?
vehicle has now been seized.
By?
Custom authority, respondent custom authority,
Why?
because suspected beetle nuts were being carried.
Suspected?
Beetle nuts,
Beetle nuts.
illegal beetle nuts.
And then?
But
That's a funny problem.
for that reason, the vehicle was been seized, Lordship.
And this has been lying out there from 2024.
Yes, Lordship. Yes.
And you have approached this for now. What has happened to the vehicle now?
Vehicle is almost depreciated, Lordship.
Huh?
Almost in condition of depreciation, Lordship.
Then why they are not allowing it? What is the order passed by them?
They had given a Lordship in
Annexure 4 page
Annexure.
34 notes.
they had asked 30% of the security amount, 30% security amount
For what?
to release the vehicle.
Why? Security of what?
The total amount and the total amount of the vehicle, that 30% as a security to release the vehicle.
Estimated seizure value 9 Iman on six-wheeler truck.
Page 34 is a order for.
So they are asking you to pay 30% of what?
Seizure value.
What is the seizure value?
9,26,100.
Annexure 5.
The seizure value is of the
Truck.
where is the direction to pay 30%? Where?
Page 34, Annexure 4.
34.
Point number 1, Lordship.
Why do you need 30% of the value of the vehicle?
This is the custom manual, as per custom manual. It is provided that 30% is to be collected on the business.
I understand
That order is
30%, 30% of the infringing item you may take. But what are you taking? Why are you taking as regards the value of the truck?
Lordship, that is a rule prescribed by the custom authority, Lordship.
Let's see
Lordship,
that.
he can file appeal under section 128 for reducing that amount. Also. That is remedy is available to him.
So you say that I should therefore ask him to go and file an appeal.
Lordship, that is provided because he is approached.
So therefore you say that the delay can be condoned.
Yes, that can be. If Lordship provide, that can be concluded. Those statutory.
Where is the provision for filing an appeal?
Lordship,
Against the provision.
128.
Huh?
Section 128 custom.
Any person aggrieved by any decision or an order passed under the check by any officer of the custom lower. If he satisfies the appellant. So he can file an appeal.
Yes, sir.
And you say that the delay can be condoned of 60 days.
Yes, if Lordship provides that.
Because the order is passed in the year 2024.
Lordship.
Now, Mr. Counsel, why are you agreed with the amount?
Lordship, the vehicle is my only source of income. I cannot pay that much.
Huh?
To
You cannot?
pay that much of amount, the 30%
Of?
of this, to release my vehicle. Lordship, I have given a representation to Assistant Commissioner, Custom Division Karimganj, page number 35, where I have mentioned the deposit amount could be up to 10% that I can do. Thirty percent is just too much, Lordship. I have EMIs to pay.
Now show me that it will also be the value of the vehicle.
The manual is, have not brought the manual.
Then
There is a.
you are not prepared.
Lordship,
So we say that you say about a manual, but you can't have it on thin air. So they have to mention somewhere that that is 30%.
Lordship, in page 34, it is mentioned.
Huh?
Page 34. Provisional lease under section 110A. But order was passed by the.
Where?
Lordship, page
No,
34.
what is the provision of 11B?
Lordship, 110 is the order for provisional release. Section 110 capital A.
Now what has happened to that proceeding? This is almost 1.5 years back.
But see, they, without filing appeal, they approach the concerned commissioner at Karimganj. He has no authority to pass order. But see, under section 138, they have to approach the commissioner appeals. We have authority, Lord, say we can reduce the amount also. Let me see page 35.
That is okay, but the thing is, now what has happened to these proceedings?
What's if notice was issued?
Mr. Counsel, what has happened to this proceeding?
The notice under section 124 has been issued.
Sorry, state of affairs, Mr. Counsel.
Page 21.
Okay, we do one thing. You go and file an appeal.
Lordship.
He says that this particular thing is, he would not insist on the delay because you have to file the appeal within 60 days. So we allow you to file the appeal within 30 days. And if you file the appeal within 30 days, then they would consider your appeal on merits.
No.
That is the only way, because you don't know otherwise your head or tail about the matter. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.C. Kyle, the learned counsel who appears on behalf of the respondent numbers 1 to 5. Full stop. Taking into account the order which this court proposes to pass, this court is not inclined to issue, dispenses with the service of notice upon the respondent number 6. The petitioner herein is aggrieved by the action on the part of the respondent authority. More particularly, the respondent number 4 in directing directing provisional release of the vehicle of the petitioner, subject to payment of 30% of the full seizure value of the vehicle, that is rupees 21,42,001 and rupees 9,26,100. The learned counsel appearing on behalf of the petitioner submitted that the petitioner is the sole breadwinner of in the family, and except the vehicle, the petitioner has no other source of income. And as such, the petitioner is not in a position to make payment of such a huge amount for the provisional release of the vehicle. For contra, Mr. Ezekiel, the learned counsel appearing on behalf of the respondent numbers 1 to 5 submits that the petitioner could not have approached this court directly, taking into account that the petitioner has an alternative and efficacious remedy in terms of section 128 of the Customs Act 1962 to challenge such orders before the Commissioner appeals. The learned standing counsel for the respondent numbers 1 to 5 also submitted that the petitioner have not approached the state authority. Instead, the petitioner has only approached the Assistant Commissioner, Customs Division, Karimganj, who has no authority to decide on an order passed by the respondent number 4. So, taking into account that a plea has been taken that the petitioner has an alternative and efficacious remedy, and this court ought not to entertain the instant writ petition. This court inquired with the learned counsel appearing on behalf of the standing counsel appearing on behalf of the respondent number 1 to 5. No, in English. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, however, submitted that taking into account the mandate of section 128(1), which stipulates that the appeal had to be filed within a period of 60 days. There is no time. The remedy by way of an appeal would not be an alternative and efficacious remedy, inasmuch as the said appeal as on date is barred by limitation. This court heard the learned counsels appearing on behalf of the petitioner, as well as the learned counsels for the respondents. And the question duly arises as to whether the petitioner would be, a question duly arises as regards whether the petitioner would be in a position to make payment of the said amount as sought for. By the impugn order dated 29/8/2024 for the provisional release of the vehicle in question. Taking that there is an alternative remedy available under section 128 of the Customs Act 1962. And such aspects can be very well agitated before the said authority. It is the opinion of this court that the petitioner should be directed to avail such remedy instead of pursuing the present proceedings. This court cannot also turn a blind eye to the fact that as on date, the petitioner would not be in a position to file the appeal, as the appeal appears to be heavily barred by limitation. However, taking into account that the respondents have taken the plea that the petitioner has an alternative and efficacious remedy, and this court is also of the opinion that the petitioner should be directed to avail such remedy. This court directs the respondent, directs the Commissioner Appeals, having his office, he's not a party here.
No, appeals is not a party.
Then Commissioner appeals where?
Shillong. Shillong.
Shillong. The commissioner appeals. Who is the appellate authority? In terms with section 128 of the Customs Act. To decide the appeal on merits, if such appeal is filed within a period of 30 days from the date of the present order. With the above the instant proceedings, then the closure of the instant proceedings shall not prejudice the petitioner in such appeals if so filed.
Noted.
May it please your lordship. Well, the petitioners are settlement holders under the respondent Gram Panchayat. And they, the petitioners number 1, 2, 3, they are operating Parghats. And the respondent number, petitioner number 4 holds the license to run a shop in the daily market. Now, the respondent municipal corporation has started erecting an wall across the bank of the river, for which my shop has been demolished and the access to the Parghat is also infringed. The panchayat as well as the petitioners, they have raised the issue with the deputy commissioner, seeking a clarification on the point as to whether this area falls within the panchayat or it is under the municipal corporation. There is no resolution on this point, but in the process, our livelihood is at stake. That is the case.
Your NIT has been issued.
No, NIT, fresh NIT has not been issued, but petitioners number 1, 2, 3, they are operating under the previous order. Your lordship will find at page 14 and 17. That is for the period up to 30th of June 2026.
It is till 36, 2025, 14.
No, it is 26.
Huh?
Because it is from 1/9/2025 for a period up to 30th June 2026. That is an error. If your lordship will kindly see page 15, it has been overwritten there. Page 15 and 17. Now, and for the respondent number 4, petitioner number 4, the license is at page 19. So he runs a shop in the area, daily market. But this shop has been now demolished because of the erection of wall across the bank of the river.
What is this shop?
It was a grocery shop run in the daily market. There is a provision in the section 23 of the Panchayat Act, my lord, that the properties within the local limit jurisdiction of the Panchayat will be based in the Panchayat. And if there is an exclusion that has to be made under section 110 by the corporation. To our knowledge, my lord, there is no this exclusion has not been carried out.
But why this particular document is being signed by everybody for issuance of an NIT?
No, the previous term of the NIT has expired. So far as the daily market is concerned. So far as
which term?
The term of the operation, it was up to 30th of this year, 30th of June this year.
It couldn't have been. If that is so, then you see page 15 and page 17 looks the same.
Yes, page 15 is from Majerhat East to Majerchar East to Dhubrighat Parghat. That has been awarded to Saminur Islam Sarkar.
Understood, but both the period is up to 36, 2026.
That is for Parghat, and the period of term for the market has expired.
Which market?
The daily market, in which, my lord, I was running my shop. The petitioner number 4 was running his shop. So the representation is for fresh issuance of NIT so far as the settlement in the market is concerned. And page 21, your lordship may kindly see. Page 21 will clarify this. The last paragraph. Is for settlement of Dhubrichar Hat and Dainik Bazar to alternatively take necessary steps to restore the Dhubrichar Hat and Dainik Bazar under Folimari Gaon Panchayat.
But you don't have shops. How do you run now?
No, that is the grievance that is for so far as the petitioner number 4 is concerned. He had the shop in the daily market, but that daily market has been now partially demolished because of the construction of wall by the municipality. So therefore, the grievance was expressed that if it is an area falling under the Gaon Panchayat, then municipality has got no business over there. Because it remains to be a property under the Gaon Panchayat as per section 23 of the Act.
Now that it is Dhubri Municipal Corporation.
Yes.
Yes. Government. Isn't it the Dhubri Municipal Corporation now? In view of the Assam Municipal Corporation Act.
Therefore,
Yes. So they can come, my lord, in terms of section 110 only if the area has been excluded from the purview of the Panchayat. Section 110 of the Panchayat Act. The situation is that neither can we operate the Parghat now because that is the entry point to the town.
Some municipal corporation. Which provision you are relying on?
I am relying on section 23 of the Panchayat Act as well as 110 of the Panchayat Act.
Now, what do you say about the Municipal Corporation Act?
No, in 110, my lord, it has been said that notwithstanding anything contained in the Assam Municipal Act, the sale proceeds of any hut situated in the area which has been excluded after commencement of this act, that shall go to the corporation from the territorial jurisdiction of the Gaon Panchayat and included in the territorial jurisdiction of the town committee. or
Therefore, I am
municipal-
saying,
Yes,
notwithstanding anything contained in Assam Municipal, the sale proceeds of any hut situated in an area which have been excluded after commencement of this act from the territorial jurisdiction
of
of
the Gaon Panchayat and included in the territorial jurisdiction of the town committee or municipality shall be equally apportioned by the state government for 3 succeeding years following the year of such transfer of area.
Yes.
Now, our case is that, my lord, the area on which this Parghat is situated and the daily market, these are still in the jurisdiction of the Panchayat. And therefore, the settlement was also.
But how will section 110 come in if now the Municipal Corporation Act has come?
Now, if the municipal corporation has come and if they,
एक और no है, Municipal Corporation Act.
and if they exclude this area from the area of Panchayat,
Therefore, section 110 is saying about a non-obstinate clause insofar as the Assam Municipal Act is concerned.
yes.
But we are not concerned. Now Assam Municipal Corporation Act has
Now,
come in.
if the area is demarcated within the corporation area, my lord, geographical limit of the corporation area, then it will be different. But our case is that, my lord, till now, it has not been decided so. It is still under this particular area is still under the Gaon Panchayat. The municipality operates in the town area of the Dhubri town.
What does the Assam Municipal Corporation Act say? As regards the area where it is to be applicable.
Like the point.
The governor may, after making such inquiry as he deemed fit and having regard to the population of the urban area, the density of population, the revenue generated so and so, and in such a, the economic importance of the area, by notification declare such areas to be a municipal corporation.
Yes.
So therefore, there is a declaration to be
Yes,
made.
and our case is that for this particular area, my lord, no declaration is existing till now. Even even at one point
So
of
that
time,
means there is a declaration, but the declaration does
does
not
not include
include.
this area.
So where is the declaration?
That of course has not been
Then-
done by us.
Without that, how is it possible?
In fact, my lord, the contention of the petitioners are that at one point of time, even the DC has written a letter to the, the Panchayat has also written a letter to the DC seeking a clarification as to whether this area has been excluded or included in the territorial limits of municipality, but there has been no response on
Seeking a
that.
clarification on the basis of a declaration is another thing.
Yes,
Now, that means whether there is a declaration or not, that is the question.
yes. So far as our
For the
instructions are
purpose of
concerned,
passing an interim order, you are to therefore bring in before this court some form of declaration which showing that it is outside.
yes. But therefore, my lord, my submission would be, if your lordship will kindly consider sending the matter back to the DC to take a call, because there are representatives.
No. I will only issue a notice asking them to make a verification and come back to this court as to whether there is a declaration or not. If there is a declaration, good. You are out, very well. If there is no declaration, bad.
Then can it be on a very short date? Because otherwise, my lord, apart from the demolition of shops and all, the access to the Parghat is also restricted.
Demolition has already happened.
For one shop. I have another shop. I am apprehending that that will also go.
Shortly.
That will also go. But otherwise, for petitioners number 1, 2, and 3, the access to the Parghat is also restricted
Very good.
because of the constructions carried out.
So you will be entitled to damages. Issue notice making it returnable on, we have it before this year ends,
My
8th
lord,
of
some
December.
some early date.
Before the year ends,
Or at least in this month.
no.
Or if your lordship gives me
Mr.
the-
Doctor, you see, if it was the PHE, the forest, the excise, as well as the PWD, I could have. But you have to also see the restraints of the PNRD. In spite of stay orders being passed, they don't get the instructions. Here, I'm not passing a stay order, then also this is the question.
Well, if your lordship will.
You have to understand this tactical difficulty.
Well, in that case, if your lordship will also at the same time grant me liberty to move the honorable court earlier, if I get hold of the declaration. I had already requested for it, but somehow or the other, my lord, it is not forthcoming. That's why, my lord,
Whether you do it or not, that is your lookout. You can always mention it
yes, my lord, that at least.
by filing an I. Issue notice making it returnable on 8th of December 2025. Ms. Enbor accepts notice on behalf of respondent number 1, 3, 4, 5, 6.
1, 3, 4, and 6.
5?
No, even as
This is Gaon Panchayat? You see, again, we have to further delay. Palimara Gaon Panchayat.
Mari Gaon Panchayat.
You should have said it by executed by secretary. Matter would have been finished. She would have accepted it. Why are you making the president? Okay, now 1, 3, 4, and 6.
Secretary is respondent number 6.
Why you are making 5 again? Okay, 6. K. Gogoi accepts notice on behalf of respondent number 2
And 7 also.
and 7. 8, how do you do it then?
Wait, Lordship, notice have to go, otherwise, Lordship, they have not made a party to the chairman.
Very poorly done, Mr. Doctor. Municipal Corporation Dhupri.
Has to be through the-
UNPS Dhupri. As regards the respondent number 5 and extra copies of the writ petition be furnished upon them, the standing counsel who represents the so and so within by tomorrow. As regards the respondent number 5 and 8, steps be taken by way of speed post. Further liberty is given to the petitioner to file speed post by tomorrow. And further liberty is given to take steps by way of the state routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner numbers 1, 2, and 3 are leaseholder for the period from 1/9/2025 to 30/6/2026 to operate Parghat as awarded in pursuance to the approval of the settlement committee in accordance with resolution number 1 dated 1/9/2025 of Alimari Gaon Panchayat Dhubri. The petitioner number 4 was issued a trade license to run his grocery shop at Dhubri Char Hat and Doinik Bazar, issued from the authority concerned of Polimari Gaon Panchayat. It is the case of the petitioner that on account of a wall being constructed now by the Dhubri Municipal Corporation, that is the respondent number A, and the demolition of the bazaar by the circle officer, Dhubri Revenue Circle, all the petitioners are not in a position to carry out their business. In that regard, the petitioners have represented before the concerned authority. However, no steps have been taken for which the present writ petition has been filed. Mr. S. Dotto, the learned senior counsel appearing on behalf of the petitioner, submitted that to his instructions, the said area wherein the petitioners have been carrying on their business do not fall within the ambit of the Dhubri Municipal Corporation, and it still falls within the Gaon Panchayat. And as such, the Dhubri Municipal Corporation has no authority to disturb the business. Further, the demolition so carried out by the circle officer, Dhubri, was also not in accordance with law. He therefore submitted that certain interim orders are required to be passed, thereby directing the respondent number 2, 7, and 8 to stop construction of the boundary wall between Dhubri Char Hat and Doinik Bazar till the disposal of the writ petition. This court inquired with the learned counsel, senior counsel appearing on behalf of the petitioner as to whether there has been a declaration, any new notification issued, providing the declaration as is mandated under Section 3 and 4 of the Assam Municipal Corporation Act 2022 in respect to the Dhubri Municipal Corporation, which should show that the area wherein the petitioners are carrying on business are outside the purview of the said declaration. The learned counsel, senior counsel, submits that he would obtain instructions in that regard. So, taking into account the above, it is the opinion of this court that for the present, this is not a fit case for passing any interim directions. The respondents, more particularly the Panchayat and Rural Development Department, as well as the Dhubri Municipal Corporation, shall apprise this court on the next date as to on what basis whether the area in question wherein the petitioners have been carrying on the business falls within the ambit of the Dhubri Municipal Corporation or within the Gaon Panchayats. On the next date, this court shall consider as to whether there is a requirement for passing interim directions.
Item 8. My lord, it speaks 6th of December.
8. 6th is Saturday.
May it please the Lord.
Yeah.
My Lord will kindly come to the tender notice, my Lord. At page 18.
Yes.
It is hereby notified that settlement of the following markets under Naga Jilla Parishad will be given for 1 year. that is for 25-26 with effect from 1/7/25 to 36/26 as per Assam Panchayat Act with the approval of the District Commissioner Nagaon. Seal tenders with port fee of 8.25 only for settlement of the markets are invited. I will kindly see the name of the markets and the government value. If your lordships would kindly come to page 19. Serial number 4, this is the market with which we are concerned. Bali Hotra Half Wheelie Market. The annual, the estimated value was estimated at Milord 83 lakhs. Now, if your lordship would kindly come to clause 12 at page 21. In respect of tender of all Bazaar Ghat, the tender offering highest value at the rate of average settlement value of the previous 3 years, along with an increase with cap of 10% on 3-year average value, will be accepted for consideration. My lord, in a continuation of the original NIT, a corrigendum was issued, which your lordships will get at page number 34, my lord. It is hereby notified that the 3 years average of the garment value of the market for which tender for settlement had been invited by office of the Nagaon Jilla Parikhad, with notice dated 7/6/25, and 10% increase thereon are as follows for the purpose of inviting tender from the interested bidder. Now, if your lordships would kindly come to serial number last but 1, my lord, Bali Khotra. Now, 2023, the government value was 1 crore 40 lakhs. 23-24, it was 1 crore 52 lakhs. And 24-25, it was, my lord, 1 crore 52. So, average is 1 crore 48 lakhs 350. Now, there could be a 10% increase. So, the settlement value has to be between 1 crore 48 lakhs and 1 crore 62 lakhs 80,000 odd. Now kindly come to the settlement order, my lord. Settlement order is at page number 37. You are hereby informed that settlement of Bali Khotra half weekly market under Nagaon so-and-so is given at the annual value of 84 lakhs. So there is a cap of 1.48 to 160. Now the settlement has been given. But look, we are the prospective bidders. We are thinking of submitting tender. But because of the corrigendum, my lord, we are thinking what to do. We did not submit our bid because the value was high. Now we find, my lord, for 84 lakhs it has been given. It's a clear loss to the government, my lord. In fact, I was the lessee for the year 2013-14. So settlement value has to be between 1 crore 48 lakhs and 1 crore 62 lakhs in terms of the corrigendum notice. If I would have known that.
If we read the clause 12.
Yes, my lord.
It says in respect of tender for all Bazaar Ghat.
Yes.
The tender offering highest value means they are fixing a highest viable rate.
Yes.
To be 10% of the 3 years average.
Yes. 3 years average is 148.
But it does not stop them from having it less than that.
No, my lord. How can they? Because they have worked out the average.
No, understood. But the fact remains that the highest is being fixed. You cannot go more than 1 crore 62.
No, my lord. Lowest is also fixed, 148. Kindly come to page 34.
No, understood. Where is the lowest fixed as per the terms and conditions?
148.
No.
Yes.
No, this is the average. But where is it said that the lowest is fixed?
No, my lord. Clause 12 says last 3 years average. Last 3 years average is.
No, offering the highest value. So they are fixing the highest value at this.
No, kindly come to page 35.
Yes.
It is mentioned here that tenders offering value more than one mentioned in column 6 will not be acceptable as per clause 12.
So therefore, they are fixing the highest value, but
Yes.
not the lowest value.
Not, the 3 years average comes to 148, not 84.
Understood.
Huh.
But the fact remains that what they have done, they have fixed the highest viable range, but not the lowest viable range.
No, that my humble understanding would be now let us come to clause 12 once again.
Yes.
Milord. Yes. Milord, let us read the vernacular. Page 30.
Yeah.
সকলো বজাৰ ঘাট ক্ষেত্ৰত বিগত 3টা বছৰৰ বন্দোবস্তি গড় মূল্য সহিতে গড় মূল্য 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ বাবে গ্ৰহণ কৰা হ'ব. That means anything between 148 and 62 will be 162 will be considered.
No.
Yes, kindly see. সকলো বজাৰ ঘাট ক্ষেত্ৰত বিগত 3টা বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্য 10% হাৰৰ ভিতৰত এভাৰেজ এণ্ড হাইয়েষ্ট তাৰ ভিতৰত যিটো this ভিতৰত word is Milord crucial দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ বাবে গ্ৰহণ কৰা.
But where does it say from average and 10% high?
This is one Milord.
Between average and 10%.
No, I'm reading it Milord for lots of kind consideration. সকলো বজাৰ ঘাটৰ ক্ষেত্ৰত বিগত 3 বছৰৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ বাবে গ্ৰহণ কৰা হ'ব. So my understanding, subject to the lordship may say is Milord, last 3 years average is X amount and maximum it can go up to 10%. In between these two figures, whosoever offers highest
So
amount
that means this corrigendum
is in continuation of the original tender.
but changes the original tender.
No, Milord, it is in continuation.
No, it cannot be because of the fact that otherwise the
No,
tender value has been
no,
put at 84 lakh,
No, lordship will kindly come to page 36.
83 lakhs.
36 Milord,
Ah.
that the Janoni, ইয়াৰ দ্বাৰা সৰ্বসাধাৰণ ৰাইজৰ জ্ঞাতাৰ্থে জনোৱা হয় যে 25-26 বৰ্ষৰ বাবে নগাঁও জিলা পৰিষদৰ কাৰ্যালয়ে জাননী নং ইমান, that is the original one, যোগে আহ্বান কৰা বজাৰসমূহৰ বিগত 3 বছৰৰ বন্দোবস্তি গড় মূল্যৰ অতিৰিক্ত 10% মূল্যৰ নিবিদা দাখিল কৰা সুবিধাৰ বাবে তলত উল্লেখ কৰা হ'ল. So it is in continuation of the original tender dated 7/6/25.
No, but if this is the year, the manner in which they fix the tender value is at 83.
83.
So if they fix the tender value at 83,
Yes.
and your submission is it cannot be from 83.
No.
It has to be from 140.
Yes.
143 to
Yes.
162.
Yes.
So you have to quote within 143 to 162.
148 to 162.
Now, they say the average to be
No, I think that the translation may not be that perfect.
yes 148 to
140 to 160.
1.48 to 1.62.
In between, whosoever bid is higher, he will be given the contract.
But how do you therefore have a tender value of 83 then?
No, Milord, it was given originally. But by virtue of this notice, which was issued on 16/6/25, it is, my lord, both has to be read together.
Then it cannot be the tender value.
That's why last 3 years value is the decisive now. Last 3 years value, average value of the last 3 years is the decisive. That's why, my lord, we could not submit. Otherwise, if we would have known that 84,000 would be the amount which should be considered, then I also would have tendered because we are in a fix what to do. Then we got to know this has happened
But you were running lessee out there
earlier.
earlier.
No, my lord, this time, because when we saw the corrigendum, now the value is much higher, 1.48. But that is also a part of the thing. But question is, when the authority themselves profess that whosoever quotes higher bid between 148 and 162 will be offered the contract, how at 84 it could have been given?
But my thing is the highest value has been fixed, not the lowest value.
No, my lord, I think that the vernacular is clear enough, my lord. Hitorot,
Yes, what do you say?
Haror Bhitorot,
Who is the Panchayat, na?
Panchayat.
Yes, Panchayat Council, what do you say? On the, what is stated out there in the translation?
Nividar Babe.
Because I've seen many of such clauses where they fix the highest value. They don't fix the lowest value. This is only for the purpose of fixing the highest value.
10%, this one is.
It cannot be more than 10%. That is what I.
Then, my lord, sorry. Oh, sorry.
What do you understand by that clause 12 in vernacular? Because the English shows otherwise.
That's it. In vernacular say
No, page 3, sir, 30.
30,
Page 30, that's
30.
12 number.
সকলো বজাৰ হাট ক্ষেত্ৰত 3টা বছৰ বন্দোবস্তিৰ গড় মূল্য সহিতে গড় মূল্যৰ 10% হাৰৰ ভিতৰত দাখিল কৰা সৰ্বোচ্চ নিবিদাহে বিবেচনাৰ বাবে গ্ৰহণ কৰা হ'ব। Means 10%, not more than 10%.
That is what I also understand.
Lordship.
Anyway, we issue notice, you file an affidavit.
Lordship, petitioners were not participate in the tender process. So
That is, they did not participate because they were thinking that 142.
locus, they have no any locus.
By the time the matter would finish off, if I am not taking up the matter, so it
No,
becomes.
Lord, the Bhitorot word makes the position very clear.
No, without means fixing the.
No, it can't be, my lord, no, my lord. তিনি বছৰৰ গড়ৰ মূল্য, not 84,000.
No, then to fix, therefore they have to amend the original tender.
It amounts to, my lord. It amounts to amending the original. It's a corrigendum. It's a corrigendum.
Chalo. Okay.
Maybe
Yes.
less than 10%.
I have to discharge the caveat also.
Well, my understanding is that the reason is in 47(1). Yeah. Rules, sorry, financial rules 47(1), the amendment.
Which one? The 2025 amendment?
Yes. But that, there, my lord, this gap was introduced. In fact, my lord, your lordship had an occasion to deal with it. Where the cabinet memorandum was, when the cabinet memorandum was challenged. Cabinet memorandum, they wanted to fix a higher cap, so that there is no excessive bidding. So in tune with that, my lord, this has been mentioned, that the highest value should not exceed 10% of the
Average.
But it does not fix the minimum value. That is why the minimum value is 83,000.
Where is the rules?
Sorry, 83. That is rule 47(1).
Which book?
It will be in this book, my lord, it will be a page 307. Or
Some finance act, it's 11(1).
It took KT amendment. 47(1). जो मायने किया था कौन rule? Constitution rule. Okay, एक मिनट. पाइसे.
Where 47(1), which portion?
Page 307.
Shall be settled by inviting sealed tender affixing so and so for such amount not exceeding 10% of the average so and so of the last 3 years for the respective huts so and so.
that is the reason behind clause.
No, average, the clear was average last year.
Yeah, Mr. Problem arises with this, because this is also 2025, Mr.
Yes.
Publication, but after that again, they come up another one. And whereby they have brought in another aspect, which is very relevant. That is, yes, 18. That day I was dealing with another matter. 19. Yes, 19 was brought in on 2nd of.
No, my lord, I think 47(1) is very clear, my lord.
Yeah.
Which has been brought with effect from 2nd of April 25.
yeah.
That is why, my lord, this corrigendum. It says seal tender courses not exceeding 10% of the average settled value of the last 3 years. How does 84 lakhs figure there? Last 3 years average is 1,48,000.
No, shall be settled by inviting seal tenders affixing so and so for such amount not exceeding.
No, my lord. No, that how to arrive at that 10%.
Mm.
10% of average settled value of last 3 years.
Yes, so the highest is being fixed. You cannot go beyond 162, but you can go to the 10 rupees also.
Yes.
Oh no, you cannot go beyond 83.
Beyond it.
You can go anything, but cannot go beyond it.
And look, one thing,
I think, Mr. Chaudhary, you need to go to the division bench.
No, my lord, my humble understanding in the vernacular, there is a word bhitoron.
Understood. I think this interpretation, the division bench will give it. Because issuing some notice out here just for that would make no sense for you.
Let me try, my lord, lordship will
Yeah.
reject my
Yeah.
interim prayer.
No,
Yes.
I'll dismiss your petition itself.
Okay,
So,
yes.
interim
Yes,
prayer, the
yes.
division bench sometimes says that, okay, go back to the single judge.
Yes, yes.
So let us finish it.
Lordship
before-
would like to say that the maximum is specified, minimum is not.
Minimum.
Yes.
So that is what
Yes.
I'll say. You should. Heard Mr. Ken
Maybe
Chaudhary,
we
the
could-
learned senior counsel, assisted by so and so. Appearing on behalf of the petitioner, Ms. Ken Bora appears on behalf of the Panchayat and Rural Development Department of the Government of Assam. Mr. S. Dr. the learned senior counsel, assisted by so and so, appears for the private respondent number 5. The petitioner herein is aggrieved by the settlement made of Bali Sotra half weekly market dated 22/9/2025 in favor of the respondent number 5 at an amount of rupees
Kita concise today.
66 23 866 on the ground that the rate at which the respondent number 5 have been granted the settlement is contrary to the origendum issued, origendum dated 16/6/2025, issued in pursuance to the notice inviting tender dated 7/6/2025. For the purpose of deciding the dispute, taking into account the dispute involved, this court issues a rule returnable forthwith, as all the respondents are duly represented. The Chief Executive Officer, Nagaon Jilla Parishad, had issued a notice inviting tender dated 7/6/2025. For settlement of various markets under the Nagaon Jilla Parishad for the period for 1 year, that is from 2025-26, with effect from 1/7/2025 to 30/6/2026. The market in question, which is the subject matter of present adjudication, is Balisatra half-weekly market, wherein the government value of the said market have been put at rupees 83,00410 and the earnest money deposit to be rupees 8,30041. clause in the term of the said notice inviting tender, which has led to the dispute in present question, is clause 12. The translated portion of the same reads as under clause 12 to deriva, page 21. Pursuant to the said notice inviting tender being issued, a corrigendum was issued on 16/6/2025. In terms with the said corrigendum, it was notified that the 3 years average of the government value of the market for which the tender for settlement was invited by the office of the Nagaon Jila Parishad dated 7/6/2025 and the 10% increase thereon were provided. As the instant writ petition relates to Bodhisattva half-weekly market, the details so provided insofar as the Bodhisattva half-weekly market are reproduced hereunder. From a perusal of the above clause, above, it is seen that for the year 2022-23, the settle rate, the Bodhisattva half-weekly market was settled at rupees 140,010. Is there some mistake here? 140,001.
No, 10 is missing in the English.
050.
10 is missing. It will be
050.
1 crore 40.
For the year 2023-24, it is rupees 152. I'll bring it as 0, make it 1. For the year 2024-25, the amount is, the settle rate was 152. I'll bring it as 0. The average of the 3 years was also mentioned as rupees 148,00350, and the 10% increased value was put at rupees 162,80385. Subsequent thereto, it is the case of the petitioners that the petitioner, taking into account the average value which have been mentioned in the corrigendum dated 16/6/2025 and the 10% increase thereof, did not participate in the said tender process, but rather However, the petitioner came to learn that on 22/9/2025, the same market, being the Bodhisattva half-weekly market, was settled in favor of the respondent number 5 for the period from 22/9/2025 to 36/2026 at an annual value of rupees 66,23,866, taking rupees 84,01001. Now, after proportionately deducting the amount so quoted by the respondent number 5 being rupees 84,01001. The petitioner thereupon submitted representation Did you submit representation?
Yes, my lord.
When?
Annexure, my lord. 1 second. Page number 40.
Mr. It cannot be. How is it possible you could have submitted on 1/7/2025 when it was given on so and so?
তাৰিখটো কিয় ভুল কৰিলে নেকি?
অসমীয়াত দিয়া আছে ন?
ক'ত? 310.
310.
31025, my lord.
Where?
Page 41 vernacular. Please have not received question. কি কৰিলা?
Is there, translated seems to be all wrong, huh?
Yes, my lord. I think it was on 310, my lord.
Had submitted a representation on 3/10/2025.
And they received is also 310.
And the respondents, however, having not acted thereupon, the petitioner had approached the court by filing the present petition. Mr. K. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that the petitioners were the settlement holders in respect to the market in question for the year 2024-25.
No, my lord.
2000?
Earlier period. 13-14. Acha.
Your lordship will see the vernacular one, that is 1213, page 43.
Page
43. But in the typing, English translation, the lord, it has been mentioned as 13.
Yes, 12-13.
for the year 2012-13. And the petitioner was interested to participate in the said tender process, initiated on the basis of the notice inviting tender dated 7/6/2025. However, the petitioner, on account of the corrigendum issued on 16/6/2025, did not participate, taking into account that the value at which the said market would be settled would be between 148 00350 and rupees 162,80385. However, the petitioner was surprised that the rate at which the respondent authorities have accepted the tender of the respondent number 5 and settled the same for the period from 22/9/2025 to 30/6/2025, which was below the average of the last 3 settlement years. The learned counsel, senior counsel appearing on behalf of the petitioner, further submitted that the implication of clause 12 of the notice inviting tender is that the amount that the settlement could not have been below the average of the last 3 years and 10% increase of the average of the last 3 years. He therefore submitted that not only the public interest has been harmed, but also the petitioner have lost a valuable right to participate. Per contra, Ms. N. Vora, appearing on behalf of the Panchayat and Rural Development Department, submitted that the petitioner herein, having not participated in the said tender process, the petitioner cannot challenge the settlement order which have been made in favor of the respondent number 5. She further submitted that in terms with the tender notice dated 7/6/2025, it is absolutely clear that the highest viable rate have been incorporated, but there is nothing which have been mentioned as regards the lower rate which could have been quoted, except the fact it could not have been below the tender value. Mr. S. Dr. the learned senior counsel appearing on behalf of the private respondent submits that this clause 12 was incorporated in the notice inviting tender dated 7/6/2025 pursuant to the amendment made to the Assam Panchayat Financial Rules 2002 by the Assam Panchayat Financial Amendment Rules 2025, the wide notification number ECF 637392/2 dated 2nd of April 2025, whereby clause rule 47(1) was amended. He therefore submitted that a perusal of the amended rule 47(1) of the financial rule Assam Panchayat Financial Rules 2002, for short the rules of 2002, would make it clear that there cannot be a settlement of tender for such amount not exceeding that there cannot be a settlement of a tender in respect to huts or ferries or fisheries or ponds beyond 10% of the average settled value of the last 3 years for the respective huts, fisheries, ferries, fisheries, ponds, etc. And therefore, this court heard the learned counsels appearing on behalf of the parties, and the question arose as to whether this court is required to pass an rule as regards they heard the learned counsels appearing on behalf of the parties and also peruse the materials on record. So the facts in the instant case are not in dispute. And as such, the question of filing any affidavit by the respondents also do not require. It is on the question of interpretation of clause 12 of the tender notice dated 7/6/2025, as well as read along with the rule 47(1) of the rules of 2002. From a perusal of the tender notice dated 7/6/2025, it is apparent that in respect to the market in question, the tender value have been put at rupees 83,410,000. In terms with clause 12, as have been already quoted in the previous segments of the instant judgment, it would appear that the tender offering highest value at the rate of average of the settlement value of previous 3 years, along with an increase with the cap of 10% on the 3 years average value, will be accepted for consideration. In other words, from a perusal of clause 12, it appeared that the bid value that the respondents have fixed the bid value below 10% equal or 10% to the 3 years average value of the last 10% of the 3 years average settlement value. This court further takes note of that in the corrigendum dated, the further finds it pertinent to take note of clause 47, rule 47(1) of the rules of 2002, which is reproduced hereunder. A perusal of the said page 307. A perusal of the above quoted rule would show that by virtue of the said rule, the settlement of huts, ferries, or fisheries by inviting seal tender affixing port fee stamp has to be for such amount not exceeding 10% of the average settled value of the last 3 years for the respective huts, ferries, fisheries, ponds, etc. Neither in the notice inviting tender, neither in the tender notice dated 7/6/2025, nor in Rules 47(1) of the Rules of 2002, there is a mandate that it is to be the average of that the rate to be quoted should be the average of the last 3 years settlement value and 10% of the last 3 years of the settlement value. In other words, the respondent authorities have not fixed the lower limit. This court also finds it pertinent to observe the submission of Ms. N. Bora that the tender value cannot be below, the rate to be quoted by the bidder cannot be also below the tender value. Considering the above, it is therefore the opinion of this court that a settlement so made, considering the above, this court is of the opinion that the basis on which the present writ petition has been structured appears to be misconceived, inasmuch as the highest viable rate have been fixed, but there is no but the lowest viable rate have not been fixed. It also does not mandate that it should be the rates, the bid value should be the average, should be between the average of the last 3 years settlement rate and 10% increase of the last 3 years settlement rate. This court also takes note of that the petitioner never participated in the said bid process. And as such, after the bid process having been over, the petitioner cannot assail the settlement. Considering the above, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed.
I think Milord will also say a few things on that clause 12 of the corrigendum, which says that between, the rate should be between, Milord.
That is why I say.
No, Milord, my specific contention is the rate should be between 140 and 160.
That is what I said. I said that therefore I said that it is not misconceived on the basis that it cannot be between the average of the last 3 years.
Yes.
And 10% increase of the last 3 years.
Okay.
That is what is.
Actually, but for this clause 12, I would not have come because he uses the word bhitoro.
Instead of corrigendum, Mr. Lordship will make it okay, because the vernacular does not say that.
No, it is in continuation of the earlier notice.
Okay.
It's clearly mentioned.
What does he say?
It's a notice.
Janoni is notice.
Another continuation notice.
Yes, continuation.
For you to say to the division bench, it's a corrigendum, he says.
No, my lord, but for the word bhitoro.
Because you say without issuing a notice, it just if I issue a notice without a stay, it makes no sense
Yes,
because
yes.
by the time it finishes off, your repetition would become infractions. So let it go from here. Let the division.
And it's a question of interpretation. Let us test it.
Yes. RKB is discharged.
Deeply.
My lord, item 48, this is the review petition filed on 6/8. Only first time today is listed as item 48. So there is little hope to get it today. So kindly upgrade this.
Will reach, don't worry. I know where to catch up the speed. Don't worry.
Item 9.
It's on the way.
May I please, the Lordship? Also, matter pertains to non-payment of contractual bill. Your Lordship, peruse the annexer 5, page number 20 of my petition. This is the work order issued in favor of the present petitioner. And in the year 2016, work has already completed. Annexer number 6 and 7, Lordship may kindly say. Just 7 is a report submitted by the assistant executive engineer to the respond number 2, where it is 100% work already completed. And total amount was also 40,15,387, out of which I have already received 23,51,300. Only 16,64,000 is yet to receive. So I submitted letter representation, but till that authority is not releasing my amount.
What was the civil code? 2016 matter, why should we? Where is the acknowledgement?
Lordship will kindly say. Annexer number 8, I have issued a letter to the respond number 2. Annexer number 9, issued a legal notice to the respond
You
number 2.
woke up after 6 years. From 2016, 6 years thereafter you submit with one representation, then followed with a legal notice in 2022. Go before the trial court.
Lordship, I have approached before the authority on several occasions. I am expecting that they will release my amount because
This can't happen. Can't happen.
I have already completed my work. Lordship.
Huh?
I already completed my work and
So what? You want money, you should have approached earlier, na?
Lordship may issue notice. Lordship may issue notice to the opposite party.
No notice. You supplied fish. Now the fish has been eaten and fish is finished.
That's a development of a bill, Lordship.
So what?
The development of a bill. And
Work order issued in so and so,
yes,
and here request final measurement on 2013.
yes.
Then final physical progress, it was done. Date of completion in 2016.
16.
And now after 10 years almost. 9 years.
But since 2021-22, at least I'm approaching the authority by communicating through letter and notices.
Approach civil court.
Lordship may
Dismiss.
allow them to take some instruction if they are ready to pay the amount.
No, nothing doing. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. Estipian appears on behalf of the respondent number 1, 2. Three and 4 here. The present petition has been filed by the petitioner seeking a direction upon the respondents for payment of an amount of rupees 16,64,062 against the tender work dated 4/5/2012. It is relevant to take note of from the materials on record that pursuant to a notice inviting tender, the petitioner was issued a letter of acceptance on 26/9/2012 Subsequent thereto, on 1/10/2012, the petitioner was issued a notice, a letter of acceptance for development of Sivastan Pulokolong
Putakolong, P-U-T-A.
Putakolong Bill under RITF Roman 16 bracket package 2, GR B. B or 8?
B.
B. Subsequent thereto, a formal work order was issued on 1/10/2012. Wherein it was categorically mentioned wherein the petitioner was to complete the work within 150 days from the date of issue of the formal work order. The records further reveal that the completion was made, the petitioner completed the work on 31/5/2016. And inspection was carried out on 7/9/2016. The petitioner thereupon slept over and did not take. Now, the petitioner thereupon, the counsel for the petitioner thereupon submits that the petitioner represented before the respondent authorities on various occasions and on 29/8/2023, a legal notice was issued.
Prior to that, 3/11, my lord. 3/11/22.
As no payment thereupon was made, the petitioner has therefore approached this court. Ekon SCTI কৈছে বুলি কৈ dismiss limitations file as per civil court. Dismissal shall not be reduced.
Item 10.
Here, my lord, I am led by counsel Mr. Bharat Singh from Delhi, my lord. He is logged in.
Lord, in this matter, my lord, I am appearing for the petitioner. This is a case, my lord, that in July 2025, the Ministry of Road Transport and Highways, through PWD Arunachal Pradesh, Lord, issued a tender for development of national highways and its part to undertake work of slope protection and in landslide mitigation measures. My client, the petitioner here, yes, my lord.
National Highway Authority. National Highway Authority.
Why National Highway is not a party?
No, my lord, it is not National Highways Authority. It is the Ministry of Road Transport and Highways. It has issued the tender through PWD Arunachal Pradesh.
Then why you are not moving the Arunachal bench?
Lord, because the impugned order, your lordship may kindly see page 151 of my petition. The impugned order is passed by the.
Mr. Counsel, it has been issued by the regional officer, Itanagar, Ministry of Road Transport, Highway. So why it is being moved here without taking the permission?
Not the impugned order. The bid was opened. The technical bid was opened by the officer who is in Assam, Milad, at Tejpur. Your lordship may kindly see page 151 of my petition.
The work is for UPR Horse 14 sector. So the work is there. Why are you moving without taking the permission from the chief? It couldn't have been done.
Lord, because of this reason, Lord, cause of action.
No. You have to move there.
Your lordship may kindly see this impugned order, because we have also made the representation before the authority at Tejpur, Assam.
Is okay, but every work is out there. Why you have not moved it?
Work is there, but competent authority is in Assam, my lord, who has to monitor the project.
Who is the
and everything is going on from that place only, my lord.
No, who is the competent authority here?
Here is the regional officer, my lord. Regional office, the regional office, the address is at Tejpur, Assam. This authority is monitoring the project, my lord, from Assam itself. My lord. And I had also made representation to the authority who is in Tejpur, Assam. Lord, issue in this petition is very short, my lord. May I?
It is not a question of short or long. The question is
Lord.
whether this court should exercise its jurisdiction when the issue involved is squarely falls within the permanent bench of this court in Itanagar.
No, my lord, it is not squarely false, my lord. As per section 20 of the CPC, my lord, the jurisdiction part jurisdiction is also in Assam, my lord. Because the impugned order which has been passed by the authority against me, declaring me non.
Made the person who have issued the notice inviting tender has been done by whom? By the regional office, Itanagar.
Regional office, Itanagar, but office is at Tejpur, my lord.
No, Mr. Counsel, kindly see page 24.
Page 24.
Ministry of Road Transport through PWD, Arunachal Pradesh.
Yes, my lord. Yes, that's correct, my lord. A tender was issued there by the PWD Itanagar, but the office, the competent authority who's having the office is at Tejpur, Assam. Your lordship, therefore, my lord, I am requesting for your kind consideration. Please see page 151, my lord.
You are concerned with which is the impugned order?
Impugned order is the order which is passed on 31st of October 2025 by the office, regional office at Tejpur, Assam, who has declared me non-responsive, and I have also made.
No, the document is at page. Is the document dated office memorandum dated 31/10/2025?
Yes, my lord.
This has been done by whom? Abhay, executive engineer for regional office Itanagar.
But he sits in Tezpur, my lord.
Your lordship may kindly see his office.
Tezpur. That is not the question out there. But the fact remains that he is from Itanagar. You have not made him also a party. How this court would do it?
My lord, because your lordship may kindly see my next page, my lord. Page 152. Regional Officer, Itanagar, Ministry of Road Transport and Highways, Government of India, House number so-and-so, Milan Nagar, Gutlung, Tejpur, Assam. This is the exact address of the authority who has declared me non-responsive, my lord.
Mr. Botaku, why it was not filed in Itanagar? There also a person can very well appear through video conferencing.
Lord,
and
even
you have not made them that party a party.
They are a party, my lord.
No, it is not.
Respondent number 3, my lord.
The problem arises because it has been done through the government of Arunachal PWD department.
No, Lord,
Wouldn't
but
it be difficult
project,
later on?
With due respect, my lord, the project is of Ministry of Road Transport. They have appointed nodal agency to the PWD, my lord. Even the Ministry of Road Transport, my lord, who is having the office at Delhi, the cause of the place of jurisdiction may also be Delhi. But
absolutely, you file it in Delhi.
My lord, but my respectful submission is, my lord.
They permit you to withdraw and file it in Delhi.
Lord, my
obviously you will have the jurisdiction. There is no problem.
No, therefore, my lord, at the same time, I have your lordship has also the concurrent jurisdiction, my lord.
I don't have a concurrent jurisdiction. No, I don't have the concurrent jurisdiction out here. Taking into account the concurrent jurisdiction is with the permanent bench out there, unless you take the administrative permission from the chief. That is the only way out. If you want to do it here, you have to take the permanent permission from the chief.
But, my lord, that is there, my lord. I go down to your lordship's observation.
It becomes very difficult later on because here it is to be done by, through the Arunachal Pradesh PWD department they have taken into account.
The PWD department is the nodal agency, my lord. It is the work of Ministry of Road Transport. And my representation is also before the authority who is at Tejpur, my lord. Therefore, I have made filed this writ petition before this honorable court, my lord, for your lordship's kind consideration, my lord. And because since I have been declared non-responsive, my lord, they can at any time declare the financial bid also, my lord. On 31st, my lord, they declared me non-responsive. On the very next day, on 1st November, I made the representation giving the details. This order, your lordship has already seen. It's a completely non-applying of technical mind, my lord. Even they have not given a single reason why my bid is non-responsive. And therefore, I have given the detailed representation. They have not, till date, my lord, they have not declared, consider my representation also, my lord.
Because this is done through the Arunachal Pradesh PWD, so therefore these people have to be made a party.
Lord, but the impugned order is passed by the regional officer of Ministry of Road Transport and Highways.
No, Mr. Counsel, you have to understand, normally it is done through NHAI or NHIDCL.
Yes.
Ministry of Road Transport on their own do not do so. It has to be, therefore, here in Assam, it is being done through NHAI or NHIDCL, or if it is falls within it is also done through the state PWD.
Lord, I
Well,
understood.
it is
Lord.
being done through the state Arunachal Pradesh PWD.
Lord, may I respond to this, your lordship's query, Lord? Because, Lord, the NHAI is an autonomous body. NHAI does not have any concern with the Ministry of Road Transport so far as the highways are concerned, my lord. The NHAI Act is also there, my lord. NHAI DCL is the Government of India company, my lord. But so far as this particular project is concerned, my lord, this is a project of Ministry of Road Transport and Highways, my lord. And this ministry has appointed PWD Arunachal Pradesh as a nodal
That is why I'm
agency.
saying the PWD
Yes.
Arunachal Pradesh is the person. You have not made them a party.
Lord, but the impugned order, therefore, Lord, cause of action also lies before this honorable court, Lord, in the state of Assam. Lord.
If you insisted upon, I'll just
No,
issue
Lord.
notice. Nothing more than that.
Lord, in the meantime, status quo.
No,
be maintained.
nothing doing. Not satisfied at all. I'll issue notice, that's all. You do it at your own peril. Yes, Mr. CKS Burwa.
Yes, Lord.
What do you have to say?
Because in this case, prima facie, what it seems as a bad for non-joiner necessary party lordship. Because Itanagar, this regional officer Itanagar is not made party.
Yes, they are the person who have to do it.
Yes, lordship. And without letting them know about the pendency.
No, Lord, we will implead them party.
This is
Sorry.
not done.
I'm sorry.
Because this New Delhi office will
go and file it in New Delhi.
Lord, then your lordship may grant me liberty, Lord. Grant me liberty to approach the Delhi High Court.
No, you can do one thing. You can very well take the permission from the chief on the administrative side and move it here. But don't you think, Mr. Singh, you need to make the government of Arunachal Pradesh, the PWD Department of Arunachal Pradesh as a party here?
Yes, your lordship.
Without that, you cannot do this.
So, Lord, your lordship may kindly do one favor to me, Lord. So far as this technical objection is concerned, Lord, your lordship may issue notice. In the meantime, I will also
No, I cannot issue notice. The problem arises if the entire jurisdiction is out there in Arunachal, either in Delhi or in Arunachal, not here. And Arunachal, you can, as you are doing the matter before me here, you can very well do the matter through video conferencing.
Yes,
link
not
there.
an issue, my lord, not an issue at all. Lord, then your lordship may give me liberty to approach the Delhi High Court because Ministry of Road Transport is there, my lord. Secretary may also be arrayed as a party. Your lordship may grant me liberty, my lord.
No, no, I give you the withdraw taking into account, but the only thing is that you don't want to, if you don't want to take the permission from the chief, because if you approach the chief may very well transfer this matter to Arunachal. You can do it from there.
No, my lord, then I would like to prefer before the Delhi High Court.
Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. C.K.S. Burwa, who appears on behalf of the respondent numbers 1, 2, and 3. Mr. So-and-so, the learned senior counsel, submits that he would like to withdraw the instant writ petition and refile the same before the Delhi High Court. Taking into account the above, the instant writ petition stands closed on withdrawal. The petitioner would be at liberty to file the withdrawal of the instant writ petition shall not prejudice the petitioner to file appropriate writ petitions before the competent court of jurisdiction. Competent High Court of Jurisdiction.
Item 11.
Item 11 is the same, lord. Same again, the jurisdiction is. Obliged.
Supplementary item 53.
May it please your lordship. This is regarding my lord, disconnection of electricity in my residential flat. This connection was done by the builder. Then I approached the APDCL authority for a separate connection, but they denied it, my lord, on the ground that the previous owner of the flat, they have some due, and that's why builder did not issue the no objection certificate.
You are the owner.
I am the owner. Response number
So
3.
when you purchase it, you take it up with your owner, earlier owner, that he has to pay that amount.
Exactly, my lord. Because response number 3 purchased the flat from the builder and executing a sale deed. While the sale deed was executed, it has been mentioned that all dues are clear. Subsequently, I have purchased from the original owner. And at that time also, I have paid all the dues. And there was a separate common electricity connection to the flat. But subsequently, the builder initiated a process to give a separate meter to individual flat. And when I approached my lord, then my connection was denied on the ground that the builder did not give the NOC in respect of my flat because there are some outstanding dues by the original owner. But when I have purchased the flat, I have paid all the dues.
You purchased from whom?
The original owner, madam.
Original owner who purchased it from
From the builder. From the builder.
So the original owner did not make the payment.
They are saying that. But from the sale deed, my lord, kindly come to page 18.
No, understood. This is between you and the original owner.
No, my lord.
Yes. It is between the sale deed which you have purchased is between you and the original owner.
Yes.
Who says that there is no dues?
Yes, my lord.
So on the basis of that, you have purchased it.
Yes, my lord.
But the fact remains that he had dues, he had misled you.
But now that it is denied by the APDCL, my lord. They are-
APDCL says that in respect to this flat, we have disconnected it because of non-payment. If you want,
Well,
we
APDCL
can
has not disconnected it.
connect it with payment.
No, well, APDCL has not.
No disconnection.
APDCL has not disconnected it. Disconnected by the builder, my lord.
So both Urera.
But
what can I do? The bill is between
because well,
you.
APDCL is bound.
Your dispute is between you and that APDCL.
APDCL is bound to.
Before them.
APDCL is bound to give the electricity.
They have not disconnected.
They have not disconnected, but they are not giving me the separate connection, my lord. I am asking for separate connection.
Separate connection, how can it be given when there is already a connection?
No, my lord. That connection was given by the builder, my lord.
Understood, but there exists a connection.
Yes, there exists a connection.
There is a connection. How can you have, if there is a meter being given to that particular flat?
No, not flat, my lord. It is given to the builder, and from that there is a common meter. From that common meter, builder is giving the supplying the electricity to my flat, my lord.
Now, a process was going on to give individual meter to all the flat owners, my lord. My connection, fresh connection was denied on the ground that there are some dues, and that is why the builder is not issuing the NOC to the APDCL, my lord. That is the only reason, my lord. But otherwise, from my side, there is no due to the APDCL. So I am seeking fresh connection from the APDCL. They have disconnected my electricity on
You can get a
27.
temporary connection, no?
Manoj, they already have a connection. What they don't have is a separate individual connection. Now, I spoken to the concerned authorities, Manoj. There is a letter issued by the builder. Now, what had happened is, Manoj, the builder had procured and set up a separate transformer, Manoj. And the original owners and the flat owners were supposed to clear the dues towards the very same set transformer, Manoj. Those dues have not been cleared. That for that very reason, Manoj.
Now, the connection goes through a transformer?
Yes, it goes through a transformer.
So you want a separate connection without the transformer?
No, my lord.
Then?
I'm not saying that, my lord.
But who, have you paid for the transformer?
Yes, my lord. I have paid. I have paid. That is why, my lord. In fact, the original owner has also paid. That is why the sale deed was executed. And in if any dispute regarding that between them, my lord, they can they can file for a money suit, my lord. If there is to realize from something from the original owner, the builder can obviously go for a appropriate remedy, my lord. For that reason, how can they deny my connection, my lord?
But you still have a connection.
That connection was given by the builder. It's a temporary connection, my lord. They have disconnected on 27th, but on my request, they reconnect it on the condition that within 10 days, you have to clear the dues.
What dues?
Of the original owner.
Ah, there it is. So you want to circumvent it?
No, my lord.
Huh?
Because there is, it is dispute between the original owner and the builder, my lord.
So there is a dispute between the original owner and the builder. Now you have purchased, where is the original owner party?
Yes, my lord. I have made them party, my lord. That's one number 4, my lord.
Huh?
That's one number 4.
So Larika Estate sold it to Ganesh Singh.
Yes, my lord.
And from Ganesh Singh,
Ganesh
you
Singh,
have purchased.
I purchased, my lord.
Now Ganesh Singh did not have a meter.
At that time, there was a common meter, my lord. For
Then you want a separate meter.
yes, for like all the individual flat, they have already got the connection, separate connection, my lord. In respect,
But Mr. Chaudhary, it appears that some problem with the transformer.
Yes, man.
Because
Truth was the transformer.
current has the electricity has to go through the transformer.
Yes, ma'am. Yes, ma'am. And now there are other individuals also who are similarly placed, my lord.
Hmm?
Apart from the petitioner, my lords, other people occupying the flat, my lord, the apartment, they are also facing the same issue.
So therefore, the only way is to go to the RERA. When you're not going, RERA will help you out. Because RERA, those terms and conditions are very much there. Who is going to disconnect?
the
Who is going to
disconnection was
disconnect if
done
you
by
don't pay
the
within 10 days?
respondent number 3, my lord.
So,
But I have,
number 3.
but
You
I
are not
I have
disconnecting.
approached the APDCL. My lord, kindly see the annexes
But
C 30
your
37.
electricity connection has to go through the transformer. It cannot be independently only to you a connection taking into account that this will require 250 watt kilowatt transformer. So under such circumstances, it has to go through the transformer. Now, if the transformer belongs to the builder, unless the builder has given it to you, how do you take care of it?
But my lord, electricity is a basic need, my lord. I
You
have
have that electricity.
I have the electricity, but if they disconnect it,
You
even
want the temporary connection, they will give you.
yes, that is why, my lord, I approach the authority.
Even the
but
temporary connection has to be through the transformer, my lord.
Huh?
Even the temporary connection has to
Then-
be through the transformer, my lords. We cannot independently draw a line
Then-
outside the premise.
Then how is he going to disconnect an electricity? He has no power to disconnect.
He has no power to disconnect, but
Then how is he, what is your threat?
because already he has done it, my lord.
Understood. How is he going to do that?
I, no, this is not- I followed that.
Because if I'm not wrong, have a looked at the building, there's an act, building bylaws or something to that effect. So there it says the transformer becomes a common property once he sells off the flat.
Yes.
So where is the original sale deed?
I have any,
Who sold to by the builder to the original owner?
it is there, my lord.
Where is it?
Page
Where is it?
15, my lord.
Huh?
Page 15.
So something more have been, what has been sold?
Regarding full consideration, it is mentioned in page 18.
Here. Or situated within the housing project commonly known as so and so, more or less so and so. Land contained in so and so and so and so. Third schedule, entry into land, all electric and all area including so and so. So here he has sold therefore this amount.
Yes.
You see, kindly come to page 25.
Schedule.
What
yes.
is being sold? All that one self-contained residential flat,
Yes, my lord.
more or less or situated within the said housing project commonly known as so
Sorry.
and so, together with the proportionate undivided share on interest into or over the land contained in the ownership block flat situated at so and so and parts thereof and over the common areas and parts comprised in the building and the housing complex whereof in the mention in the third.
Yes, my lord.
All electrical including electric meter for running of the water pump and so has been sold.
Yes.
So this becomes a common part.
Yes, my
So
lord.
you see, space for installation of the Iman meter board and space for installation has been sold. Where is the transformer?
C, E, my lord. Space for installation of electrical transformer meters, board and space for installation of
This is
electric.
for space.
Yes.
Meters and board and space for installation. So you need to bring on record the agreement which was entered in
Agreement to sale, my lord.
and then come up with your case that he cannot stop you. That there is a transfer has already happened. So when the transfer belongs to him, it does not stop them to provide the electricity connection to everyone. You don't have a society
Uh,
or you are not in good terms with others.
Till then, my lord, no society was constituted as per my information goes, my lord.
How many people are there in that flat?
It's a very big area, my lord. It's more than 200 flats, my lord.
So everybody must be facing the same trouble.
Maybe, my lord.
Builder must be doing it. You do one thing. You have the electricity connection.
Right now, we have, my lord.
Okay, we pass an interim order not to disconnect and we have it within another. Have it on 24th. Today is 10, or not 28th.
Yes.
You serve by way of the state. And then we take it up. And you look into, there are 2-3 judgments of the division bench of the court, wherein the same issue arose as regards the transformer. And wherein the division bench held that this transformer becomes a property of the year. In the meantime, you file an additional affidavit bringing on record that.
Agreement to sell. Yes, my lord.
Issue notice making it returnable on 28/11/2025. Steps be taken. Mr. B. Chaudhary accepts notice on behalf of the respondent number 2. Huh?
2 minutes.
Mr. K. Gogoi accepts notice for respondent number 1. As regards the respondent, extra copies of the writ petition be served upon them during the course of the day. As regards the respondent number 3 and 4, the petitioner is directed to take steps by way of speed post. In addition to that, the petitioner is also directed to take steps by way of dusty upon the respondent number 3 and 4, routed to the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner hearing is that the respondent number 4 had constructed a multi-story building.
That's number 3, my lord.
Respondent number 3 had constructed a multi-story building in the name and style of
Mrs.
Larika Green Valley. Isn't it?
Yes, madam.
Good stuff. One of the flats bearing number
2/107Z.
2/107 bracket G in building number 2, floor number 1, at measuring 1315 square feet with one covered parking area was sold to the respondent number 4 by the registered deed of sale dated 26/3/2021. The said deed of sale have been enclosed as Annexure A to the writ petition. From a perusal of the said deed of sale, registered deed of sale, it appears that the respondent number 3 sold to the respondent number 4 not only the flat in question, but proportionate right in respect to the land as well as rights over the common areas. Which includes all electrical installation, all electrical wiring, including electric meter for running of the water pump and lighting of the common areas, pathways, staircase, etc. The petitioner thereupon purchased the said flat in question from the respondent number 4 by the deed of sale dated 14/3/2022. And it is the case of the petitioner that on the basis of the rights which flowed upon the respondent number 4 by the deed of sale dated 26/3/2021, the same rights flowed upon the petitioner in respect to the said land and said flat and the common areas. It is the further case of the petitioner that the respondent number 3 have provided temporary electricity connection, though was required to provide separate electrical connection. On account of some dispute between the respondent number 3 and 4, the respondent number 3 have threatened the petitioner that the electricity connection would be disrupted. And it is under such circumstances the petitioner had approached the APDCL authorities for granting a separate connection. The APDCL authority having not considered such requests, the respondent's hearing, the petitioner hearing has approached this court by filing the present writ petition. Mr. N.J. Katoni and the legal counsel appearing on behalf of the petitioner submits that electricity is what is that? Is an essential
service, madam.
Is an essential service. And in view of the judgment of the Supreme Court in the case of Inri Dilip Det versus so-and-so, reported in so-and-so,
2022 SCC online SC 810.
the respondent authorities cannot. The respondent number 3 cannot disconnect the electricity on account of a dispute between the respondent number 3 with the respondent number 4. And at the same time, the respondent number 2 who is the supplier, also cannot reject or not consider a request so made by the petitioner. Per contra, Mr. B. Chaudhary, appearing on behalf of the respondent number 2, submitted that individual connections have not been given to the petitioner as well as various other flat owners on account of a request made by the respondent number 3 in view of request made by the respondent number 3. This court have heard the learned counsels appearing on behalf of the petitioner as well as the respondent number 1 and 2. It is the opinion of this court that the electricity being an essential service on account of certain disputes between the respondent number 3 and respondent number 4. It is a prima facie. The petitioner cannot be deprived of the electricity which the petitioner is presently enjoying. The question as to whether the epidemiological authorities are justified in not providing the separate electrical connection to the transformer which have been installed in the multi-storied building is a question which would be looked into at a later stage of the instant proceedings. However, taking into account that the electricity is an essential service and there is a threat that the said electricity would be disconnected by the respondent number 3. It is the opinion of this court that the petitioner is entitled to certain interim directions. Accordingly, till the next date, the respondent number 2 and 3 shall not take any steps for disconnection of the electricity connection of the petitioner, which the petitioner is presently enjoying, subject to payment of the dues by the petitioner to the respondent number 2. The name of Zia Assam may also be shown before the
On 28, on 28.
28. You take test by year. And you see that particular act, BL, one is RERA, and there is another act. Yes, I think RERA will be there. RERA categorically says what are common, like, and there is another act. I forgot the building,
Building.
where it category. No, the Assam Act. There is not this one. There is an Assam Act in the state legislature of Assam, where it provides what are the requisite, what are the common facilities have been defined. So their transformer comes in. So you develop your arguments on that.
There's a judgment of the Supreme Court also, Malad Mulchan Gulati, I believe. Common area has been defined.
Common area has been defined. Yes. So this is it. You develop your argument. Yeah. What is this?
This matter can be, the item number 36. That also may be taken up along with this. Because there they have filed an affidavit.
Where is Union of India?
It's BRO, my lord, basically, HL Gupta used to be representing in the earlier, in item number 36.
Huh?
HL Gupta was representing BRO, my lord, in item number 36.
That day I passed some order, no?
But was directed, my lord, restrain them from, my lord, issuing
Age group,
work order.
what is it? Yeah, considering a direct decision not to issue any work order or enter into contract with any bidder in respect to the contract till the next date. Court is also. So you are in the second requisition, you're challenging this 31-7.
31/7/25, as well as subsequently they have another issue dated 15/10/2025, same method. Same wording for the, my lord, report ending, my lord, June 2025. 31/7/25 was, my lord, the workload report ending March 2025. Other wordings are same, my lord. And my contention here, my lord, the direction of debarring me from my lord, the order by which I have been debarred from future, my lord, tender process of the BRO is not governed by the, my lord, tender, my lord, the contract agreement. There's no clause in the contract agreement whereby they are empowered to, my lord, debar me for this, my lord, workload report, etc. There's only.
You have filed affidavit, Mr. Counsel?
Yes, ma'am.
What is your stand?
He has filed in 39.
Where is the affidavit filed? You have not filed affidavit?
File.
You have filed?
7th, yes.
Huh? When did you file?
On 7th.
Why it is not here? Some additional affidavit has been filed here.
There is one of some subsequent development is there, my lord, on 7th. They have approved my EOT method, extension of time, my lord, which was pending since April. That has been approved. So thereby question of slow progress, etc., does not come at all, my lord.
And what is this additional affidavit file?
This additional affidavit, I have enclosed the letter dated 7/11/2025, whereby the authority has granted the extension of time, my lord, that has been approved and refixed the, my lord, date of completion. On this view of this, my lord, approval, my lord, this slow progress, etc., what has been, my lord, those workload return does not arise.
Huh?
Because this, my lord, the approval has been granted to the, my lord, extension of time. In the workload report, they are basically going that I was slow in progress. Now the cause which I have assigned in my, my lord, application for, my lord, extension of time, that was recommended by the authorities. Although, my lord, lately now they have approved it. So the milestones have been, my lord, refixed, my lord. Now it is up to, my lord, 31st of March 2026.
But where is your affidavit?
No, it is showing, my lord, file in the online status, but perhaps, I think it has not been tagged. We filed it on 7, my lord, it is showing online that this file. In between, my lord, Saturday, Sunday, perhaps.
Now what have you challenged here?
This letter dated 31/7/2025 and 15/10/2025 at page 226.
What is that 1510?
Same, my lord, stereotype, my lord, only the return is my lord, June 2025.
Page?
Page 226.
This is 31/7.
31/7.
And the second one?
245.
Now this is slow progress.
Slow progress.
In respect of a different contract, ma'am.
Now you have filed an additional affidavit.
Well, one additional affidavit dated 24/10/2025, that, my lord, one document, which is also, my lord, they have filed by your affidavit. That's the appendix, annexure 5 to appendix 1A.
So the question is 31/7 as well as 1510. Mr. Gupta, is it permissible as per your contracts to debar in this manner? Terms of the tender, not in this one. Otherwise, in these tender, if there is a slow progress, can you debar somebody from participating?
Yes, my lord, that is there the clause, my lord, which earlier also I have pointed out, clause 2.1.14.
Of?
My lord, if my lord is taking the old writ petition, my lord, the previous 6046, my lord, the first writ petition.
That is
Page
RFP,
58.
not the contract agreement.
Huh?
That is RFP, what he is
That is-
referring
that-
to.
That is what governs, my lord, the contract.
Okay,
it
let
is
us
governed
see
by-
that. Where is that?
that is
Page
just Page 88, my lord.
2.1.4.
Yes, my lord.
Fails to set up so and so, fails to mobilize so and so.
Fails to complete.
2.1.14, my lord.
2.1.14.3. No, that's what fails to complete or has missed any milestone in progress, not commensurate with contiguous unencumbered project length, ROW available when, even after lapse of 6 months from the respective project milestone scheduled completion date, unless extension of time has been granted by the authorities. Here, my lord, in the bid document which the petitioner has submitted, they have filed it by way of an additional affidavit. There they have suppressed this fact. If my lord takes page 323. This is the requirement of the tender conditions, my lord, at the time of submitting the bid, these informations had to be disclosed. In 6046, one of the first petition, page 323. The information was asked, my lord, whether he has failed to achieve complete or has missed any milestone and progress not commensurate with continuous unencumbered project. But he has stated nil. Both the
For
information.
this one, page 323.
323.
Did you say a nil? But there was a delay.
There was a delay.
No, my lord.
And there was,
My lord, that has been published only on 31st of July 2025. And my lord, the last date of submission was, my lord, 18/6/2025. And this slow
No,
progress.
no, it's okay. Let us
Okay.
not forget about 31/7.
Yes, my lord.
Let's not take into account here.
Yes.
But did you miss any milestone?
My lord, so far as the, my lord, EOT, the milestone one, that was in time. So far as my lord, EOT two was concerned, there was a, my lord, delay. I have filed an application for extension of, my lord, time.
But did you meet, here it says fails to complete or has missed any milestone and progress not commensurate with the contiguous unencumbered project length ROW available even after the lapse of 6 months from the respective project milestones, scheduled completion unless extension of time has been granted due to authorities default or force majeure.
So this force majeure application for grant of EOT was pending.
You filed your reply, na?
I filed, my lord.
We do one thing, you want to file any reply to that?
Yeah, I'll be filing.
You file your reply within 10 days. And then, and in the other matter, we issue notice only.
My lord.
My lord, those to be state, my lord.
No, we can't stay that.
No,
You
but
do
because
ask.
this is
No,
an
we are-
independent.
you see, we are only concerned with this particular thing. Yes, another thing is, that is one aspect. But the second thing is, you say you have blacklisted them by this 31/7 as well as 15/10. You have blacklisted them. But where is your provision that you can blacklist in this manner?
That is there, my lord, because that is a previous contract. My lord, we take that.
Understood,
But the conditions under earlier contract, my lord, that permits blacklisting. The conditions are different of both the contracts, my lord.
So if there is a provision for blacklisting, can the blacklisting be automatic?
No, my lord, the notices were given. This 31/7/25 order has, prior to that, my lord, several communications have been made regarding poor progress, to which the contractor has not replied, leading to passing of this order, the consequential order.
Did you mention that it is the case of blacklisting? See, you asking him to complete within a time is different.
My lord.
But did you put him to notice that you are going just, there's a chance that you will be blacklisted, no? Because of these reasons.
But
because you see, blacklisting is a civil debt.
No.
There's a requirement. All judgments say that one thing that you have to issue a notice. That notice should also be understandable or can be conceived by the person concerned to the effect that this particular viewer, they are trying to take steps for this thing. So that he can reply that, look here, I have not done all this thing. But the tenure of 31/7 and 15/10 categorically shows that there is it's a directly you say they don't allow him to participate, meaning thereby you have blacklisted him. So did you follow the procedure for that?
No, the contract clause provided, my lord. If my lord perused page 153 of the new, this motion matter, my lord, 6362.
153. Yes.
My lord, this one, it starts, my lord, from page 151. It's a clause, my lord, article 23 relating to termination. And the relevant clause, my lord, is at clause article 23(6), my lord, page 153, Roman 6. The authority may at its discretion without terminating the contract and allowing the contractor to continue with the existing contract, place the contractor in the negative list for any of the following reasons.
failure to achieve milestone proportionate to the encumbrance free ROW handed over. And my lord, the first clause is attracting, my lord, he failed to achieve the milestone, therefore, my lord, he was placed in the negative list. Thereafter, my lord, clause 7, consequence of placement in the negative list.
He has skipped the proviso, my lord, attached to that particular clause.
Yes, yes, provided that the authority shall issue a 15 days notice time to the contractor before placing him in the negative list, and upon evaluation of reply, if any, shall take final decision, such a notice shall not be issued without the approval of an officer below the rank. Prior to that, my lord, before placing him in the negative list, by that communication dated 31/7/25, several communications were issued, my lord, notice were issued asking him to improve the progress of the work, failing which he was put in the negative list.
And consequences is 2 years.
Yes.
So it is nothing but a blacklisting. So the question is, did you act in terms with the provider?
Yes, notices were given.
No.
So produce it.
Yes, that we have annexed in our this affidavit also, which we have filed.
In that affidavit, you have enclosed the
Communication. Yes, all the communications, my lord, relating to the earlier contract, where he has failed to miss the achieve the milestone. Yes.
You have seen the copy?
Yes.
So there was there any notice?
Those are not the notice as contemplated by this, my lord, rule, my lord. And it is question of, my lord, placing in the negative list for a moment, my lord. But what he is saying, my lord, is that in the future contract, I'll be barred. That is covered by clause 10.3.4 at page 93.
Page 93.
Page 93.
No, kindly come to 154.
That's it. Basically, and upon evaluation reply, if any, without approval of the officer, provided upon satisfactory on the matter of which contractor has been placed in the list, the contractor authority may allow the contractor to be deleted from the list consequent placement, or shall not be eligible to beat any of the authorities character project for a period of 2 years and the date of. Yes, that is also there. Madam. It is there. This is this clause and 10.3. That is 2 clauses there, madam. Now here, putting me in the negative list, they have to give me a specific so-called notice, giving me a time to reply, and then they'll pass a note. So notices, whatever there in the are only for the purpose, only asking me to improve, not this.
No, here it has been categorized, shall issue a notice.
Yes, ma'am.
To the contractor placing him before Iman upon evaluation of his reply. So it has to categorically mention that we are going to take action in terms with this particular clause 23.6. 23.16.
It is there, my lord. These notices are there.
And your reply must be there. After he submitted a reply, you must have passed an order.
That is a consequent 31/7 order. The 31/7 order, my lord, by which.
No, you see, kindly see 154.
Yes. Did you final decision?
No. This can't happen.
That letter, my lord, clearly state as per the terms of the contract, action will be taken if we don't achieve the milestone.
One
396.
Now, against this, did he reply to this particular thing? We are not concerned with this one, but more particularly this one, when they are saying here, what is 10.34?
That is debarring for in future contract, page 93.
10.3, which one?
Page 93 of the new writ petition, my lord, WPC 6362.
Huh?
WPC 6362. Page 93.
Does it say anything about the negative plead?
No, my lord. It says, my lord,
But in this.
ineligible for bidding in future project of the authority. That's what they say here.
10.3 Roman 2.
10.3 Roman 4.
That relates to, my lord, obligations prior to the commencement of the work. Not relating to.
No, this is construction of the project. That's what they also referred, but this clause also not applicable because this is applicable only in, this restriction is applicable only in respect of the work which is.
But one notice was there on 27th of March 2025. Is not achieved by so and so, the authority will be constrained to initiate action as per so and so due to your default. But then also, if you are initiating action, you have to initiate action by law.
So cost on that.
Not done. You don't want to file your reply,
now-
but I think we need to close that with petition. There's a stay.
That is causing.
So therefore, what we do, you see, from the materials which you have brought, it doesn't appear that you have taken any action in terms with this particular clause 23 properly. You should have categorically mentioned to the effect. You see, if you see the judgment in Gorkha, categorically says that the particular person not only should be issued a notice, he is also to understand the notice. You have to categorically say that this is a notice in terms with the proviso. Why haven't you done that?
That subsequent writ petition, my lord, we will file affidavit. The
Huh?
First writ petition, my lord, the grounds for rejection of the financial bid.
You see that if 31(7) does not remain, that means they are not put in the negative list. Then the entire thing goes. So the thing is, you want to file an affidavit, you file an affidavit, but the only thing is you're going to delay it.
No.
You process whatever it is, look into how it is and do whatever you feel like. But the fact that it is not in consonance with the proviso, we should have made it clear. Matter could have, we say it is not the happiness of this court to set aside, but you have to be clear. The Supreme Court has been clear all along that you have to be very clear to that effect that why you are issuing this notice and what is the content and under why. Now, if you say that this is being done in terms with the proviso to section and to clause 23.16, what stopped you that you have not done it in this progress? It's no point keeping these matters pending for long. But anyways, I will give you an opportunity because if I'm going to set aside both these things, then I think I should give you at least 1 week time to file your reply. If you want to file a reply. Because taking into account, I have to continue the stay. Because this has been done on the basis of 31(7). So this I will therefore do it and have this next week. We can finish it off. Huh?
My father prayer, my lord, for stay, my lord, because
What?
there some other tenders are also pending. my lord.
No, we'll see on next week. No heavens is going to fall. You have waited. Unless this court had given you the good idea of challenging, you wouldn't have challenged it. I only asked you to challenge. You said, okay, I'm filing a separate. Then, and then also after that, you could wait for almost how long for filing this particular petition? You didn't file it the next morning. So no, heavens will fall for next week, isn't it, Mr. Gupta?
No.
Issue notice, when should I give it? Mr. Gupta?
My lord, after, my lord, seven days, my lord, any date. my lord.
I'm giving you only for the purpose because tomorrow when I set aside, you may not say before the division bench that look at this judge didn't give me a time.
No.
When?
7 days time, my lord.
Okay. Issue notice making it returnable on,
19, my lord, in that case.
let's have it on 20.
My lord.
So that 20 I can finish it up at 2. issue notice making it
20.
returnable on 20/11/2025. Mr. H. Gupta accepts notice on behalf of the respondent numbers 1 to 7. Extra copies of the writ petition be furnished on him during the course of the day. The petitioner herein have assailed the communications dated 31/7/2025, as well as the communication dated 15/10/2025, whereby the petitioner have been put in the negative list.
Well, by this, they don't say they have put me into negative list. It is his interpretation is they have put me into negative.
That is the negative.
My lord,
Not the
they
PLR
don't
is
say,
the-
my lord.
that
It is
the
his
negative
argument, not on the, my lord, this letters.
Not the demand.
It is the decision of the, my lord, issuing authority that he should not be, my lord, debarred. He should be debarred.
Here it is, Ganesh, shall not be permitted to participate.
Lordship, my lord.
So therefore you are in the negative list.
But the, my lord,
It helps you, Mr. Saikia.
that is there, my lord, that is there.
It helps you
Right.
because then you take the advantage of the proviso.
Yes, that they have mentioned in the affidavit. Yes.
So therefore they say so. So let us therefore take it. Put the petition in this negative list. They by communications dated 31/7/2025 and 15/10/2025. That too without following the mandate of the principles of natural justice, and more particularly the proviso to clause 23.1 Roman 6, which categorically stipulates not only that there would be a notice, 15 days notice given to the bidder, to the person against whom actions are contemplated to be put in the negative list, but also there is a requirement of passing an order. Mr. P.J. Saikia, the learned senior counsel, appearing on behalf of the petitioner, further submits that the order dated 31/7/2025 and 15/10/2025 under no circumstances can also be said to be orders passed on the 23.1 Roman 6, inasmuch as there is no reasons assigned insofar as the petitioner Mr. H. Gupta, the learned counsel, appearing on behalf of the petitioner, submits that taking into account the interim order passed by this court dated 24/10/2025 in WPC number 6046/2025. The project in question have been stalled and as such submits that the petitioner herein and submits that taking into account that the communications dated 31/7/2025 and 15/10/2025, which are the subject matter of the present writ petition, are intrinsically connected with the other writ petition, the respondents would file their affidavit, if so necessary, within on or before 18th of November 2025. He further submits that in WPC number 6046/2025, the petition respondents have already filed the affidavit, and he would obtain instruction as to whether there would be a requirement of filing any further affidavit. So, taking into account the above, this court is not inclined to pass any interim order, inasmuch as an attempt shall be made to dispose of the writ petition on the next date so fixed. It is, however, observed that in the circumstance the writ petition cannot be disposed of on the next date so fixed, this court shall consider consider as to whether any interim order would be required to be passed. List accordingly. This matter on so and so, interim order passed earlier shall continue till the next date.
Can I pray for a, another date, my lord? 25/11, my lord, can it be possible? 25/11, my lord, instead of 20, my lord, can it be on 25th? 25th, Tuesday.
That, yes, my lord, can it be little earlier, my lord, because
In that case, 18th, my lord, 18th, my lord, 18/11, because 20th, some personal difficulty, I'll be having. 18th or my lord, 25th,
Does he have personal difficulties?
I will know.
No. This is the only issue, Mr. Council.
Yes, yes.
And senior counsel doesn't have personal difficulties for matter.
All right.
Yeah, the lordship, since the matter that non-redeemable security deposit money lordship. Last occasion lordship. The inquiry and the complaint was solved for lordship.
I have received that, madam, lordship, though they have filed any documents, so lordship will find. The last flag mark is the notice given to the petitioner adjusting the security deposit, madam, because without executing what, madam, fraudulent payment was made, madam. First flag mark, madam, I have marked in, madam, fishery department has, madam, they have made on, madam, regarding fraudulent payment. And.
We are concerned with which one?
Madam, last page, your lordship, last flag mark may be seen, madam. The notice given to the petitioner, madam.
Huh?
Last flag mark, madam. Notice to the petitioner, madam, on 9th April, madam. Last flag.
Yeah.
In that notice, madam, it has been clearly mentioned that, madam, without executing work, he has taken up the money of 44,39,000. And the security deposit, which now, madam, the petitioner is claiming, has already been adjusted, madam, against that excess payment. And now he has been asked to pay, madam, the remaining amount of 27,41,829, madam. And he has not responded against this notice till date, madam.
So we have not received any notice, lordship.
You do one thing, you bring this aspect by way of an affidavit.
My.
See, work is completed in the year 2017, lordship. The certificate is there.
That's-
Completion certificate. Lordship, let.
No, but Mr. Gogoi, you have to also understand that if there is a recovery proceedings initiated against you, how can this court direct them to pay?
But the notice, we have not received till date.
They say that it has been issued to you, but you have a look at it. Then obviously, then I'll have to place it, you have to challenge this notice. If this be so. Huh?
So let them bring a notice
Yeah.
along with the complaint, lordship.
Not executing any work, madam. No
No,
work.
lordship,
was
work is completed, lordship. Whether
Whether work has been done or not, that is again, that if that is a question, then it will be done before the civil courts.
Yes, madam.
whether the complaint is there, not a known, lordship.
Complaint is
Complaint
also
of Dulal Bora.
Yes, it is there.
They said that the inquiry initiated on the basis of the complaint of one Dulal Bora.
Ms. Judas, the learned additional senior government advocate, submits have placed before this court an instruction issued by the secretary to the government of Assam Fisheries Department, wherein the complaint petition filed by Sri Dulal Bora, as well as the various reports have been placed before this court. In addition to that, there is also a communication issued to the petitioner dated 9/4/2021, whereby the petitioner was asked to refund an amount of rupees 27,41,829 after adjustment of rupees 13,22,006. Inasmuch as it is the case of the respondents that the petitioner had not carried out any work and have received an amount of rupees 4439.39 lakhs.
Right.
Full stop. It is the opinion of this court that the respondent should bring on record such instructions by way of an affidavit so that the petitioner is in a position to rebut to such allegations. Ms. Udas, the learned senior government advocate, submits that within 2 weeks such affidavit will be filed. Accordingly, list this matter again on 10th of December 2025. The affidavit be filed on or before 1st of December, on or before 1st of December. Full stop. Petitioner given the liberty to file the reply thereagainst on or before the next date.
Lordship, the call for complaint, Lordship,
Everything she will bring on.
Complaint, my lord, someone has to bring on, my lord, otherwise, my lord, how? can
Complaint
people-
or no complaint,
Yes,
is
my
not
lord.
that if you have received any amount without work, then
Yes,
the
my lord.
civil court is there. This is not for a court, read court to pass an order.
Not 44 lakhs, my lord.
Obliged.
Yes, Councillor Ali.
I prefer short accommodation.
Don't ask for thought accommodation. We are concerned with, yes, he has asked, on the last occasion I have given to
In
Mr.
fact,
Mia.
Lordship, in our affidavit, Lordship, we have taken a stand, your Lordship, at page 68. All the files have been handed over.
Have you put the petitioner in the chronological list?
That I tried to seek instruction. Lordship, then personal appeals be called for. They are not responding. Because they say, your Lordship, the records are not available with us, them. In the morning also, I have tried to contact them, your Lordship. Let them come before this honorable court.
And what are the source?
Or instructions which engineer officer giving in a field. The reports are not available in that department, in the division of the executive.
That means if there is no records available, meaning thereby you have not complied with the order passed by this court on 13/6/2017. So both the chief engineer who has been directed to take note, comply with the order dated 13/6/2017 have not been complied with. It is apparent.
Because.
Whatever may be, he has to therefore say, examine and do whatever may be. He should have come up with a report or say something to that effect. But nothing has been given. On the other hand, the respondent number 4 has filed an affidavit that the petitioner, these records are lying in some other branch and so and so. So you have to settle it out amongst yourself. It is not that the petitioner can be debarred from getting the payment on account of the laxity on the part of the departments. Ms. B. Bhuya, the learned senior counsel who represents the BTC, submits that the respondents in the BTC have not responded to the instructions so sought for by this court dated 24/10/2025. Mr. Arendas, appearing on behalf of the chief engineer of the Water Resource Department, submits that the water resource that the office of the chief engineer, water resource department does not have records. From the stand which have been, from the stands so taken by the councils appearing on behalf of the respondents, therefore, it appears that the order dated 13/6/2017, passed in WPC number 5025/2014, still remains to be complied with. Merely stating that the records are not available cannot be a ground to deny the relief to the petitioner if the petitioner is otherwise entitled to the amounts as claimed. Considering the above, this court further takes note of that by the order dated 24/10/2025, this court only inquired as to whether the petitioner was put in terms with the chronological list for payment in terms with the judgment of the learned full bench in the case of Tamser Ali versus State of Assam and others reported in 2008 4 GLT 1. Such instructions is also not being provided. Under such circumstances, this court fixes this matter on 1st of December 2025. The chief engineer, water resource department, as well as the additional chief engineer Kokrajhar Zone, water resource department, are directed to bring on record their stand by filing the affidavits. Next, fix 1st of December. On or before 28/11/2025. Failing which, they shall appear before the spot at 10:30 a.m. to a video conferencing link to be provided by Mr. So-and-so, the learned counsel who assists Ms. B. Bhuya for the BTC, and Mr. R.M. Das, the learned counsel appearing on behalf of the Water Resource Department.
10.
Yes, what is this?
Well, the affidavit, we have prepared it to be filed tomorrow only. There is a vernacular next time it needs to be translated. Otherwise, I have served a copy to my learned friend. One thing I would like to place one document.
Call for fresh tender for operating of the ordinary repairing and flood damage FDR against the funds sanctioned by the so-and-so for the year Iman and Koza. What remains here?
My lord, it is infractual.
Infractual. Mr. Hawk.
21/22.
Mr. S. Hawk submits that taking into account the relief which have been claimed in the instant writ petition, the writ petition has become infructuous. Taking into account the above, the writ petition therefore stands closed as infructuous. Mr. P.
16.
Appears for the penal building part. APDCL.
My lord, I received a copy of the affidavit I received a copy of the affidavit today from them. I think possibly it's not in record.
It has been submitted by the learned counsel appearing on behalf of the petitioner that an affidavit in opposition has been filed by the APDCL authorities. He therefore submits that some time may be granted. You want to file reply?
My lord, some time may be granted. I'll have to go through, my lord.
He therefore submits that some time may be granted so that the petitioner can go through the affidavit and if necessary, file a reply. List this matter on 10th of December 2025. In the meantime, liberty given to the petitioner to file the reply.
Deeply obliged.
17.
May I please, Your Lordship? Your Lordship, I pray for 1 week time to file a rejoinder.
Affidavit filed?
Yes.
I gave you time to file reply. Counsel appearing on behalf of the petitioner submits that some time is required for filing the reply. It is noticed that this court by an order dated 8/9/2025 granted time to the petitioner to file reply. Taking into account the submission, this court for the ends of justice grants a further and final opportunity to the petitioner to file reply on or before 3rd of December 2025. List this matter again on 8th of December 2025.
Much obliged.
18.
May I please, Your Lordship? Lordship, on the last occasion, Your Lordship had directed them to file a affidavit stating a specific date of and payment of the amount, Lordship, to the petitioner. They had admitted the same in paragraph number 5, my lord.
Lordship, the admitted amount is Lordship 11,91,250. Here in the affidavit, Lordship, there is no any specific mention regarding the admitted amount, Lordship. That's why my lordship directed us to obtain instruction in respect to admitted amount, Lordship.
No, the fact remains that he is entitled.
You see, he is entitled the amount, Lordship, 11,91,250, Lordship.
Then
Lordship, I give direction to the authority to.
this court, the petitioner heard Mr. M. Paivala, the learned counsel, appearing on behalf of the petitioner, and Mr. K. Goyal, the learned counsel, appears on behalf of the respondents. So the petitioner herein is aggrieved by the non-payment of an amount of rupees 11,91,250 on account of
Supply of
in respect to the work order for supply of computer sets in connection with the census 2020 under Nagaon district. The record reveals that the respondents have duly admitted the said amount payable to the petitioner. But the said amount have not been paid to the petitioner on account of the funds not being available. When the matter was listed before this court on 24/9/2025, this court inquired with the learned counsel who represents the respondent number 3. As to whether the said amount, whether the petitioner is entitled to the amount of rupees 11,91,250 or any other amount, and when the said amount would be paid. Today, Mr. K. Gogoi, the learned counsel, appearing on behalf of the respondent, have placed before this court an instruction issued by the Additional District Commissioner Nagaon dated 10/11/2025, which is kept on record and marked with the letter X. From a perusal of the said instruction, it is apparent that the amount of rupees 11,91,250 is the amount to which the petitioner is entitled to. However, it is further seen that the respondents have also received an amount of rupees 13,50834 for the census operation in 2021. And there is also steps being taken for obtaining the sanction from the government in the headwise fund distribution and approval. No, for sanction, yeah, for disbursement of the entire amount of IT infrastructure along with stationery and replacement head. So taking into account that the amount have been duly admitted and the respondents are in possession, have due funds to the tune of rupees 11,91,250, which is the entitlement of the petitioner. This court directs that upon production of the certified copy of the present order, the respondent, which the district commissioner is?
Respondent number 2, Lord.
The respondent number 2 shall release the said amount of rupees so and so 1191 to the petitioner within how much?
2 months period.
Within 2 months from the date of production of such certified copy of the order. With the above, the instant petition stands disposed.
Deeply alive.
20.
Yes.
As per the last order. I repeat my letter. One thing is there, my lord, your lordship sees that, whatever, my lord, there was no extension, my lord. However, there was one thing which I would like to point out to your lordship is that when the work order was issued, your lordship comes to annexure 2, page 28 of the petition. The annexure 2, page 28 of the
That was only for 3 months.
my lord, and after that, so when this was, the work order was issued to the petitioner, he was, your lordship reads it, the second, if I may allow to read it, you know. The SAD is pleased to approve so and so, as the lowest bidder and, allow to operate the officers canteen at Janta Bhavan so and so, subject to compliance of the terms and conditions of the tender documents and signing of the contract agreement to be initially for a period of 3 months, 2 months, so that the quality of food can be properly evaluated and on the complete satisfaction of the SAD. Now, what happened, my lord, lordship says, as soon as the 3 months commenced, my lord, the complaints started coming in, my lord. That I have given in the affidavit, my lord. The complaints from the people who have eaten in the canteen, my lord. The complaints started coming in for the quality of the food, the rates, my lord, different complaints, my lord. Then what happened, as soon as he, because that time was 21, my lord, he entered, if your lordship sees, 321.
You file an affidavit on the basis of this.
Okay, I'll do that.
Pursuant to the order passed by this court on 22/10/2025, an instruction has been produced by Mr. A. Cooper, appearing on behalf of the General Administration Department. The said instruction is kept on record and marked with the letter X. It is apparent from a perusal of the said instruction that the respondents contend that although there was no specific work order being issued, but the petitioner continued to run the canteen.
When a work order was issued, contract was on, the agreement was on. The work order was there, work order is at page.
Here in C, in this regard, no such extension was issued to the petitioner, and as per the available record, there is no work order number 2. You are requested to provide copy of such here mentioned if the same has been produced before the court by the petitioner.
First work order was there, second
No,
work.
there is no second work.
Second is on.
No, sir, there is no.
Fine, fine.
So, taking into account on the ground that the petitioner was running the canteen in Cochin. Mr. Counsel, don't disturb when this court is dictating. Considering the above, this court is of the opinion such a stand be brought on record to the by filing an affidavit so that the petitioner is in a position to rebut to such allegations. To list this matter again on 5th of December 2025. The affidavit be filed on or before 26th of November 2025. So the petitioner would be at liberty to file reply on or before the next.
Interim order that may be continued.
Interim order passed earlier shall continue till the next.
Items 21 to 25.
My
What
lord,
is this matter about?
in 22, they have filed affidavit, so my friend, learned senior friend is hearing, 22, my lord, may be taken. In affidavit, they have filed in item 22.
Your matter?
Item number 22, my lord. So they have filed affidavit, my lord, I have filed reply also, my lord. This is a non-permanent of contractor bills, my lord. In spite of, my lord, I have completed the work till now date, I have not been paid anything, my lord.
What is your stand?
May I submit one thing, my lord? My lord, as per our stand, my lord, these works are not permissible under MNG and Rega, my lord. Now they have filed a reply, my lord. They are saying some guidelines were there in this issued by the state government. As per that, those were permissible, my lord. On that specific, my lord, issue, my lord, lordship may grant sometime I will take written instruction on that, my lord. Because our stand is that non-permissible work.
Mr. S. Dutta, the learned standing counsel of the PNRD submits that the PNRD department had filed their affidavit in opposition in one of the petitions, wherein it is the stand of the PNRD department that such work on the basis of which the petitioner is claiming amount does not come within the ambit of the NREGA guidelines. However, it is also submitted that an affidavit in reply has been filed by the petitioner wherein it is being contended that the work in question is covered by certain government guidelines. And in that regard, Mr. Dutta submits that he requires to take instructions. List this matter again on 3rd of December 2025. In the meantime, the respondent in the PNRD department is directed to bring on record their stand by filing a rejoinder to the affidavit in reply.
Hello.
The said rejoinder be filed on or before 1st of December 2025.
Hello.
Yes, BTC.
This matter may also be fixed in one bed, lordship, but appears with there's no instruction as to this.
What?
Instruction has not been received.
Instruction, how many times should we give you an instruction? It will dispose of code with BTC.
Ramshed.
Say as per Tamsir Ali.
Yes, but we didn't.
Tamsir Ali, I'm a BTC order. Verification 1 month payment
Payment lordship.
as per Tamsir Ali.
As per Ramshed. Then lordship may not give that within that period.
Obviously, no, verification 1 month.
Yes,
Payment Tamsir
my
Ali.
lord, obliged.
27.
May please your lordship. My lord, item number 27 and supplementary item number 57 are similar matters matter. Earlier they were take together, my lord. It is, here I am selling the delayed release of security deposit money, my lord. So lots of paid the last order. Affidavit was to be filed.
The line, they have no comments regarding interest. What is allows, my lord, I can file a short affidavit to the. That was the specific direction.
Paisa. Supply 57.
How much is the amount?
My lord, in item number 27, my lord. The amount is 41,74,300 rupees, my lord.
Ah.
In supply item number 57 and in item number 27, it is 27,25,344, my lord.
If you allow me, 2 days, I will file the affidavit. I have got it, request.
But Mr. Gogoi,
Yes, sir.
you understand why I did not permit you to appear in one of the matters and ask M. Satya to appear in that police matter? Do you know why? Because of what you do is every time saying that I'm going to file an affidavit, but at the end, the affidavit never comes here.
My lord, last chance was already given, my lord. In fact, my lord, if your lordship uses the last two orders, my lord, lordship has given chances, my lord. They had not filed, my lord. And in fact, if your lordship uses the
In fact, it appears, and within 2 days also, commitment has also gone for a 6. I don't believe your commitment. Mr. Gogoi, you are an additional advocate general, you have to be, whenever you give a
But in
commitment
several
before the
days I have
court,
filed.
this board does not want to just brush aside. But this is what is appearing. This is becoming habitual.
No, I have filed, my lord. In every case, I have filed.
Oh,
Not that-
yeah.
Where required, my lord.
Yeah,
This-
therefore,
lordship
1710
is the
and
last-
direct liberty is given to the respondents to file an affidavit giving reason
So here, my
as
lord,
to
on-
why interest should not be imposed upon the respondent on the amount due from the date the amount was payable to the petitioner. Pursuant to the order that has placed before this court an instruction.
my lord, in fact,
So
last.
this is how it is
No,
going
instruction
on.
I have placed, my lord. Town, my lord, so far the interest.
First of all, if it is a question of security deposit,
Yeah,
you have
it
to-
ought to have been, my lord, because it's a, my lord, central funded, my lord, 2015. On the last occasion, I placed a, my lord, review committees, my lord, instruction. They say, my lord, by 3 months, they will, within 3 months, not only of the petitioner, whatever liabilities there of the other contractors relating to the same, my lord, scheme, that will be, my lord, verified. Now, central government. says
where is
that-
the question of verification
No,
here?
my lord, the central government says that, my lord, it is the state who will have to bear the entire burden. Now, I placed it, my lord, last week.
Lordship
But even then, my lord, so far as this no comments part is concerned regarding the interest part, I will place it, my lord, along with that whatever is there. I assure, my lord, in 2 days it will be filed, it will be on Friday.
We're having it on Friday.
Yes, my lord. Before that, by Wednesday, I will file. At least you can.
Mr. B. Gogoi, the learned additional senior, additional advocate generals appearing on behalf of the PWD department submits that the respondents he has received the instructions and the affidavit will be filed on their behalf by Wednesday without fail. This court accordingly fixes this matter on 19th of November 2025. This court further gives liberty to the respondent, a final liberty to the respondents to bring on record their stand by filing affidavit by 17th of November. It is made clear that if the affidavit had not been filed, is not filed, this court shall proceed with the disposal on the basis of the order so passed by this court on 17/10/2025. We shall take the order.
My lord, similar order in item number 57, my lord.
Same.
Okay.
May I please, your lordship, this is the case is that, my lord, one tender was called by the respondent number 4. And my lord, that has been completed and thereafter, my lord, that has been cancelled. My challenge is that, my lord, cancellation. My lord, kindly turn to page 18. Annexure 1, that is the big documents, my lord.
Or this one,
Yes, lordship,
below 10%.
below 10%.
So as per that judgment, means that can be permitted as per that government notification.
Yes.
What is the stand?
Lordship, affidavit we have filed, your lordship. At paragraph 6, your lordship, paragraph 6. It will be DFO, your lordship. There are deponent stated on 10/5/2023, the additional principal chief conservator forest and chief executive officer, state Campa issued letter to all divisional forest officers, Assam. A proposal state letter states that the limit of financial bid value shall be between -10% to +10% of the internal estimate. It also says that the bid value only in the range of 10% below to 10% above the estimated cost will be accepted. Any bid beyond the above said limit shall be rightly rejected at the time of opening a financial bid. Further, it was directed to insert said instruction in tender document, your lordship.
So it was not there in the tender
It
document.
was not there in tender document.
So then,
So thereafter, the petitioner offered a tender value of 38.51
Yeah, 17 point.
17, which is 18.01 less than estimated amount, your lordship.
so therefore,
So, for your lordship, we take the annexure A, your lordship, page 18. It's on the basis of this letter, your lordship, on this letter, since there was the condition was not there in a tender document. That's why it was suggested. It's not that we accepted it, we given him work there, then after we cancelled it. We have not handed over anything, just because the condition was not there. As per the PCF, since
so therefore you want to cancel it.
we will cancel the whole process, your lordship.
But what do you do about the notification of the government?
But this funding, the issue here is that a funding agency is a Campa, your lordship. Funding agency is the Campa.
What is that?
It's for instance, regarding to this, I don't know exactly the full form of Campa. It's for this afforestation. It's for keeping the money, your lordship, for afforestation, refunding the money, your lordship, keeping the money. They utilize the money in development and all that stuff, your lordship. The central, it is central fund, your lordship.
Central government has given a clear go by to -10%, 15%. Where is Mr. B. Gogoi gone? He has only said that central government doesn't want this 10%, 15% thing. They want to give it to everybody. Whoever is the lowest bidder, you give it to them. But as per the central government's,
But we are part by this letter. That's why it was cancelled. That's why next time.
where is that the campus says?
Page 80, your lordship.
State Iman issued letter to all divisional officers and he has so and so a copy of the letter. This was letter was issued when?
It was issued on 10th May 2023.
And then?
Then-
And in the instant case,
Instant case, 18/1/2025.
when was it cancelled? When did he issue the notice inviting tender here?
18/1/2025.
And in spite of that, what is the 10-1?
That was cancelled on 21.
Develop the eligible bids. Where is 10-3? The limit for financial bid shall be between so and so to so and so. So bid value only in the range of so and so above it be accepted. Any bid beyond above limit shall be slightly reduced. All the internal estimates and inputs shall have an objective including the upward side. So this has been issued in 10/5/2023. And this was not the condition there.
There was no condition there. Thereafter, page 81, your lordship. Page 81. There's a letter issued to the DFO, your lordship, from the CF Eastern Assam Circle. It states that above reference, undersigned right to inform you that after scrutiny of tender document furnished by you, it was observed that the evaluation criteria for accepting plus/minus percentage are not mentioned in the standard bid document on NIT. The evaluation criteria, section 4 of the SBT complete deviates from the standard criteria in the SBT. Hereby you request revise the SBT as per existing guideline, proceed e-tender of the above mentioned work without delay.
So your stand is that the Assam Procurement Act and the Finance Department has no value. Or the governor's direction has no value. The additional principal chief conservator forest circular is have more important than a notification issued under 161. Is that the stand?
That's not my stand, Lordship, because we are bound by this letter. That's why we have to cancel it. We are, since it was issued by the additional PCCI, he asked us to cancel the tender because
the condition was not there. And since no condition was there, so that's why they said you refloat the tender. It's not that we are.
Is the
are you-
finance department a party?
Finance department is not part.
Yes, Mr. B. Gogoi. Ah, here he is. What about the finance department circular? Would it override? Because this is done under some procurement. They wanted to procure something. So the government have initially passed an order. Earlier you had minus 10%, plus 10%, all these things aspects were there. But the governor came up with a particular, the finance department has come up with a particular circular notification that if it is less than 10%, then there will be more earnest money and all these things will be, the security deposit will enhance. So this is being done. So therefore, the question is whether this notification will override the letter which have been written by the additional principal chief conservator of forests to the divisional forests. Or is it something like for land, forest has exclusivity from the revenue? Does it mean that for other aspects also the forest will have exclusivity? That's the answer. We'll have it, we'll finish it off very soon because this controversy needs to be finished first. 2nd of December, we'll finish it off. List this matter, having heard the matter at length, list this matter on 2nd of December 2025 for disposal, final disposal at 2 p.m. Mr. Arbor Pujari, the learned standing counsel for the finance department shall appear and apprise this court whether the notification dated 30/7/2024 issued by the finance department shall override the communication dated. What is the date of your communication? 7/5?
10/5/2023.
10/5/2023 issued by the additional principal chief conservator of forest.
And see the executive officer. state
Interim
cap.
order may be continued, I think. Interim order may be.
Interim order passed earlier shall continue till the next.
Public.
Mr.
I'll
Arbor
submit the
Pujari's
copy.
name be shown in the cause list.
I will serve the copy.
In the notification, it is stated this notification shall come into force with immediate effect. It means a prospective nature.
Understood. No, they did it in the year 2025. Yeah, that is, now what has happened? In 2025, they have issued a notice inviting tender. Now here his rate is below 18%. So therefore it cancelled it. Now the question is, in view of this notification, can you cancel it on that ground? Or should you put that it's additional security? So therefore the question is whether the finance department has exclusivity or forest has absolute, like the in respect to land.
29.
Yes, what is this
Congratulations.
Oro Trade and Commerce?
May it please your lordship.
Ah,
My lord, in this matter, we have received the affidavit in opposition filed by the railway authorities, my lord.
or demurrage charges.
Yes, my lord.
You filed. You want to file a reply?
Yes, my lord.
Okay, the counsel appearing on behalf of the petitioner submits that the affidavit in opposition has been filed by the respondent numbers 1, 2, and 3. And the petitioner would like to file a reply. List this matter on 10th of December 2025. In the meantime, the reply is filed on or before 8th of December 2025.
In 10th of December, I'm not available.
What?
I may not be here until.
Okay. When are you available?
After that, 14
14?
14 December.
It's a Sunday. I'll help you. 15?
15.
You file your reply by 12th.
My lord. Much obliged.
On or before, huh?
Fine.
Before you file it. Yes, P. Sharma, affidavit not there. What is the matter about?
My matter we relates to, my lord, we have prayed for remission and readjustment, my lord.
By senior reasons, recovering Mr. P. Sharma is in Delhi.
Understood, but the thing remains out here, madam, you have to understand that the court cannot stop. If I am ill today, the court would not stop. somebody else will be taking over. Don't you think so? Then it can't happen like that. Earlier, I have already accommodated you on 19/9/2025. That's almost 2 months back. So, or should we then construe that all matters of AFDC and all, the court should say that, okay, we should not appear, not take up anything, all declare it cyanide, delete. There's another council for AFDC, nobody else. We do one thing, we ask that the managing director to be present. If you don't file your affidavit.
Next week, I will consult with Sharma, even one council also.
No, they have to file it. The court cannot wait. Neither for me nor you. So it has to, once an accommodation is okay, but not more than once. It has been submitted that the affidavit would be filed on behalf of the respondents on or before, within a week's time. Considering the above, list this matter on 3rd of December 2025. The affidavit be filed on behalf of the AFDC without fail on or before 24th of November 2025. Was the liberty given to the petitioner to file reply, if any, on or before the next date.
32.
Mr. Deka, what is this?
Lordship, I have supposed to tax some.
What, payment?
Yes, Lord.
Limited amount, Lordship, my Lord, the disposal of the matter under.
How much? Admitted,
7,74,288.
24,000. Econ আছে, tax authority, police office. DGP direction, the payment 6 months.
So item 34 also similar.
What?
Item 34.
Lordship, I need some time. Lordship.
No, not come. 34 will have it some.
Lord.
Don't take up all the money of the government so fast.
33.
Lord.
Yes, FCI, where is it, Mr. BK Singh?
The director to file affidavit Lordship on the last.
Huh?
They have not filed anything till today.
They have not filed affidavit. Neither BK Singh has appeared.
Yes, Lordship.
Who is appearing for the FCI?
Well, Mr. KP Butter was appearing in this matter, for the FCA matter. So I pay for some like.
No, earlier Mr. BK Singh was appearing.
After Mr. Patel has been appointed as a returning council of FCA.
Is it? Okay, and what happened? Why affidavit has not been filed?
Sometime maybe. We have already sent for vetting.
Okay, it has been submitted that the affidavit on behalf of the FCI has been already sent for backing and will be filed within 7 days from today. So, taking into account the above, list this matter on 5th of December 2025. Affidavit be filed on or before 26th of November 2025. Liberty given to the petitioner to file reply on or before the next day.
People have paid for accommodation. I have not.
Mr. K. Gogoi, the learned council submits that some more time is required for obtaining the instruction as regards the petition as to whether the amount so claimed by the petitioner has been admitted or not. So accordingly list this matter again on 21st of November 2025. In the meantime, the verification as to whether the petitioner is entitled to the amount or not be placed before the court.
Problem.
35.
May I please the Lord? My Lord, matter pertains to settlement of sand binding unit, my Lord.
Affidavit filed.
Affidavit filed, my Lord.
What do you want?
My Lord,
You want to file reply?
my Lord, reply not necessary, my Lord.
Okay, fantastic. What is it?
My lord, by filing this affidavit in opposition, my lord.
Huh?
By filing this affidavit of opposition, my lord kindly page
What do you
31.
want here? Shall not be issued directing authorities settle so and so with the petitioner forthwith in terms with the letter of intent and allow him to operate. Fellow, what do they say? They want to allow you?
They have said, my lord, because of DSR, my lord, non-issuance of DSR district.
DSR district survey report, your lordship.
District?
Survey report,
What report?
district survey report.
Ah,
Nowadays, what happened, if you allot, before executing, allotting a mahal, a DSR report has to be prepared.
ah,
Then after we can go for the execution of the agreement.
ah.
In this matter, a DSR report is not yet prepared, your lordship. That's why we have not,
Who is to prepare?
the authorities, your lordship. We are on the process preparing it because there's only 1 month and it's not written only one mahal, your lordship. There's various mahals are there, we're preparing the report.
So how much time would it take for the DSR report?
It takes some time, your lordship.
How much? 1 month, 2 months, 3 months?
Most, it may take 3 months or more than 3 months, your lordship, because it concerns all the mahals, your lordship. And further, we have not executed any agreement, neither we are asking for pay any case, your lordship, till now.
But you have not terminated also.
We are not terminated, your lordship.
But you are saying that you are willing to still give in, provided you prepare the DSR report.
DSR.
So the fault is yours. The fault is because you are to prepare the DSR report. So we have it after 4 months. In the meantime, you give an update as to whether the DSR report has been.
My lord, petitioner has already
The
deposited.
petitioner hearing, no, your time will be extended accordingly.
Because the time starts when the agreement is executed. No agreement is executed.
But the petitioner deposited 15 lakh, my lord, in terms of LOI, my lord. They have
Yes,
directed.
that's his bid amount. That's his bid amount he has deposited. It's not said that we are
The
terminating.
petitioner herein has approached this court seeking a direction upon the respondent for issuance of the work order, na?
Yes, final settlement, my lord.
For issuance of the mining lease in respect to the Kothak Hall Sand Mining Contract Unit 1B in terms with the letter of intent dated 2/11/2024. It is the case of the petitioner that the petitioner have also deposited the bid amount of rupees 15 lakh
Yes, sir.
and have also submitted the due documents which are required. However, the respondents have not and executed the mining lease. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the respondent submits that it is also the mandate of law that the district survey report has to be prepared. He duly submits that the said report is to be prepared by the respondent authorities. And as such, the same would require some time. He further submits that the petitioner need not worry, taking into account that the petitioner's interest would be duly taken care of from the date on which the mining lease is executed. So considering the above, this court inquired as to how long would the district survey report would take. It was submitted that it may take more than 3 to 4 months, taking into account that the district survey report has to be prepared for in respect to various mines of the minor minerals. In that view of the matter, leaves this matter for update on 2nd of February 2026 as to whether the district survey report in respect to the petitioner have been made or not. In the meantime, steps be taken by the respondent authorities to expedite the process of preparation of the district survey.
Okay.
Okay, this order you would not have got if you have mentioned it in the morning. Yes, as Doctor, the learned for revenue and so and so.
May it please, your lordship.
Yes, what is your stand? You have not filed your reply?
No, lordship, reply is not required. Lordship, they has already admitted 2 work orders. But according to us, we have been issued with 3 work orders. And according to that, we have also completed the
works which have been allotted to us. But only dispute is that they are admitting only 2, but according to us, there are 3 work orders.
Cool.
If I may take your lordship to page number.
No, it is okay. You say the value of the work order allotted to the petitioner comes to 9 lakhs, whereas the amount claimed by the petitioner is 14 lakhs.
Yes, lordship.
They are
Lordship,
claiming only 9 lakhs.
lordship, 9 lakhs is on the basis of 2 work orders. And whereas the amount 14 lakhs is on the basis of 3 work orders. They have admitted 2 work orders, but they have neither denied the first work order, which has been allotted to us on 30/11.
Yes, Mr. Borbujari.
My lord, in the affidavit which we have filed, my lord, by the respondent number 1, that is the revenue department, that starts, my lord, at page 31. There is no admission part say here, my lord. Please to see, my lord, paragraph 5 at page 32. Running page number 30.
Value of the work allotted to the petitioner comes to Iman,
Yes,
whereas the amount claimed by the petitioner accordingly by letter to the office of the year to furnish documents.
yes. Now,
On
this-
receipt of the requisite documents as the stated, the entitlement claim of the petitioner can be ascertained and the office will take necessary
Yes.
steps.
this is the step.
Copies of the work orders dated so and so and so and so are enclosed. So they have enclosed the 3 work orders.
Yes, lordship.
They are not denying to that.
No, these are the work orders. Now, my lord, whether this has been completed, now we are on the issue of making payment. Now, whether work has been done in pursuant of the work order, that can be ascertained and verified, my lord, by the office of the district commissioner. Because these works were done under the SDR.
And what is the DC doing? This is not a party.
Therefore, lordship may be pleased.
So this is a party.
No, this is the party. Lordship may be pleased to see, my lord, page 40. For a moment, my lord.
Yeah.
This
You have
is the-
written to them, no?
Yes. Because we are the sanctioning authority. We cannot sanction anything, my lord, head and tail. There has to be.
Why, what about the directing you to make a verification? Because there are various forms of verification orders. First is the first verification order, which I normally pass, is having 4 stages. First, whether work orders were issued. Such work orders were sanctioned.
Yes.
Thereupon, whether work orders have been issued to him. Number 1. Number 2, after the work order is issued, have he completed the work? Third, after completion, have he submitted all the documents of completion and then to carry out the verification? Number 3, after verification, if it is found that he is entitled to, after all this verification, he will be paid the amount. The payment will be made within 6 months.
That means, my lord, the entire exercise has to be done within the outer limit of 6 months.
And if he has not submitted the documents on the basis of which he can claim, just for example, the work orders, all these things, his bills and all, then he is not entitled. Pass that order.
Lordship can.
Hello, it will hear you. It's either direction. This way. He appears for, you appear. But only thing is what your officers, they don't understand that these directions are pro. One has to satisfy first, work order is there. Second is, work order is there, whether he has submitted all the completion. Third, after completion, whether he has given all the details for the submission of the bills, whether the final bills have been prepared, completion certificate has been done. Now, what happened? Your officers, they do not look into those directions. They say, we have not carried out the verification. Right? You look into these only. And if it does not fit into one of the criteria, you may reject it. Then he can go to the civil court.
Absolutely. We are obliged, but if those parameters are set in my lord's order.
Huh?
If those parameters are set out.
These are there, but not for the, what you call the police. Police is different. Police is for, because they come up with that we are liable to pay, so police direct pay within 6 months. And then you have the BTC. The BTC follows like this. First verification within 1 month, then pay as per term set. PWD verification 1 month, pay within 6. So this is all fixed. So I only tell them normal. It is 4.
I'm obliged.
Obliged, lordship.
Yes. Oh, this matter. Where is the ASTC? Huh?
ACC council. ACC council is not your right.
His name is not shown in the public?
It's shown, it's shown.
Specific orders, yeah.
None has appeared on behalf of the ASTC in spite of the name being shown. Considering the above. Considering the above, that there has been no explanation given in spite of this court have inquired into by order dated 3/11/2025. This court states the renewal permission granted in favor of the respondent number 3.
3 and 4.
Lordship, if I may, I'm here on behalf of my senior Lordship, Mr. Soma for the ASTC. Lordship, we have received instructions, Lordship, if I may.
So they are going to float a fresh tender.
Yes,
Have you cancelled the tender or not? Cancel that or not?
yes, sir. It has, the entire thing has been scrapped, Lordship. We are restarting the entire procedure.
When have you cancelled?
Lordship, I'm not aware about that.
Ask your chief general manager to put this by way of an affidavit. And as well as also bring on record when you have cancelled this extension given on 12/9/2020.
Very
We'll have it on again on 19th of November.
19.
It has been brought to the attention of this court by Mr. So-and-so, the learned counsel appearing on behalf of the ASTC, that when it was noticed that the renewal was granted in favor of the respondent number 3 without any tendering process, the Assam State Transport Corporation Authority decided to float tender in accordance with the prevailing rules and guidelines for operation of the toilet block and complete the tendering process within 45 days from 31/10/2025. Taking into account the above, this court requires the managing director of the Assam State Transport Corporation to bring on record such stand by filing an affidavit on or before 19th of November 2025. List the matter on 21st of November 2025 for an update. The communications were placed before this court on behalf of the ASTC counsel for the ASTC is kept on record marked with the letter X.
Made you the lordship. The matter pertains to non-payment of the pending contractual bill of the petitioner. On the last occasion on 24/10/2025, my lord was pleased to give a direction to my learned friend.
How much?
My lord, in this, my lord, we have a pending due of 7,97,000 and some odd figures, my lord. 7,97,936 in the prayer portion, page 24, my lord.
Have they filed affidavit?
No, my lord, they haven't filed affidavit. my lord.
Why haven't you filed?
Examine and verify.
Four prong. Dispose 6 months.
I'm obliged, my lord.
Next is the same. my lord.
Item number, my lord, 59 is also similar, my lord, pertaining to a different work, my lord, completed by the same petitioners. They are also, my lord, they have not paid the amount.
Meticulous for no.
No, no, these are different, for a change, my lord. I'm obliged, my lord.
Non-payment of bills, my lord, 1,93,200.
What?
Non-payment of supply bills, my lord.
Assam clock stores.
Yes, my lord. These are
You
appropriate.
want to get the money from whom?
From Samagra Shiksha or something.
Huh?
From,
4 and 5.
yes, my
How
lord.
will the headmaster pay?
This supply order was issued by the school authorities. But funds.
This has been done under this aegis of mission director. Yes,
yes.
Samagra Shiksha. Mr. Yes, Samagra Shiksha.
Yes.
So Samagra Shiksha, these payments have not been made. Because they don't make payment, they don't have the money, that school. You, it is only when you pay. Isn't it?
Yes.
Get your instructions.
I will have the instruction.
These are supplying here of some,
Lots of.
wait, Mister, you are appearing?
I don't know. Number one. Anyway.
Okay. Just find out and come up with your instructions. This matter has been delayed for long. I have issued notice as on 1/8/2025. Okay. Mr. It seems that the respondents number 4 and 5 have not put in appearance. Be that as it may, the amount to be paid by the respondent number 4 and 5 has to be on the basis of payments to be made, payments to be sanctioned and made by the respondent numbers
This one,
two.
two, my lord.
to stop. Under such circumstances, this court inquired with Mr. B. Gogoi, the learned standing counsel of the Samagra Shiksha Assam, as to why the petitioner have not been made the payment. To stop. The learned counsel submits that he would make necessary inquiry and thereupon apprise this court. Accordingly, list the matter on 8th December 2025 for an update.
Copy of the petition may be.
Yes,
Of 61.
Now only, huh?
not this one.
United Drilling Tools, where is Mr. R.B. Pukon gone? Oh, he has gone.
Mr. Lordship, the leading counsel had to leave
Huh?
court due to some urgency.
Lordship, during pendency of the petition, already the petitioner was put on holiday list. Lordship, by order dated 10/10/2025, against that, as per my telephonic instruction, they have prepared an appeal, Lordship, before the appellate authority, director of operation.
Then,
So that is pending.
what is being challenged here?
So in this case, they have challenged the issuance of the so-called notice cum suspension order. And as in terms of lordship order, subsequently proceeding has been culminated into the passing of, into an order of, passing of the banning list, banning order.
Okay,
We
so
have-
in
we
the
have-
meantime, you have passed that order.
Yes, that is not challenged in this.
You have filed your affidavit?
Yes, sir. Is
Okay,
170.
affidavit, you want to file reply?
Yes, Lordship.
How much time?
1 week or 10 days, Your Lordship.
Hello? Okay, list the matter on 8th December 2025. In the meantime, the reply be filed on or behalf of the petitioner to the affidavit in opposition filed by the respondents on or before and 1st December, on or before 26th November.
Grateful, Lordship.
For orders, item 37.
Contempt, Kokrajhar, Gokhaigaon, so and so. Oh, this is a long time matter. Mr. Borpujari, anything?
And I have received the updated instructions, my lord. On the last occasion, taking into account, my lord, the detailed comprehensive affidavit filed by the respondent, my lord. By the respondent number 10, who was, my lord, then the principal secretary of the revenue department. And my lord, one instructions were also placed. Accordingly, lordship has fixed the matter, my lord. Giving some reasonable time.
This thing I have already taken note of.
Yes, now, my lord, I have received the instruction, my lord, that this will take some further time because it pertains to the way back in the year 1996. They are getting the information.
Would these people during their lifetime get it? Huh? Within their lifetime? If this contempt is going on from 2018,
2018, why, my lord, this content is going on 2018? In the meantime, my lord, there was an appeal and therefore, my lord, this content is proceedings was, my lord,
there may
for a
be.
prolonged period, my lord.
But then also, you can't help it.
No, no, no.
Contempt, if it is not given, the people will lose faith in the judiciary.
Absolutely, lordship, but lordship will kindly see, my lord, the sincere approach of the respondents. It is not that, my lord, we are sitting over the matter, my lord. There is no deliberate violation. This cabinet subcommittee has been formed, my lord.
Understood, that was done on 16/7.
Yes, it is-
Now what has happened? Have they given us this? I am having it after 4 months. Mr. Arbuzari, Learned Counsel appearing on behalf of the respondent submits that, respondent number 1 submits that, the respondent number 10 submits that, no final report have yet been submitted by the subcommittee, cabinet subcommittee, which was constituted by the notification dated 16/7/2025. List this matter again on 21st of January 2025. It is, this court expresses that it would be in the interest of justice that the cabinet subcommittee submits the report in the meantime. In as much as the petitioners herein have been waiting for their dues for pursuant to orders being passed by this court since almost a decade. Yes, Mr. B. Gokul.
This is the instruction I got from the Commissioner Secretary Finance.
You were supposed to file an affidavit, na?
No, Lord, he has asked us to place the report. We are seeking, my lord, further, my lord, 4 weeks time so that we can conduct the inquiry and my lord, the hearing officer can be, my lord, go through application. That is the last prayer made, my lord.
But what about the remaining amount?
The remaining amount, my lord, on 7/11/25, the PWD has requested the petitioner to give a calculation.
Why will the petitioner give a calculation? Are you,
Well, then we will do that, but because tomorrow again he may dispute, my lord,
you want to do it?
from my lord,
No, don't delay that because this will have a.
No, they are waiting, yes, that's why within this month we will try to, my lord, make the payment, so we'll have to take a cut-off date till October, otherwise, my lord, we'll have to.
You
move the
cut,
pro-
you take a cut-off date by this October,
Yes.
or the date, you take it another 15 days from there and then make the date. If you are to get it ready by 8th of December, just for example, today we are on 10th of December. 8th of December, take a cut-off date on 8th of December and make the
Yes, that's
start,
what, my lord,
because
we'll
by
have
the
to-
time 8th comes, your financial approval and he gets the money.
Yes.
But you have to do it, that one
We are
amount,
working on it.
the amount would not be much, taking into account
No,
now this
they-
amount has been paid.
Roughly around 2 lakh, not much.
So do,
It will be done.
do it, will. Then I will leave out that thing as to what about the interest? And when this have to be taken from these officials, let this
At least should be completed.
umbrella remain the
Yes.
shadow.
Yes.
Yes. It has been submitted, that the amount, you have got 11 lakhs?
Yes, Lord. 11 lakhs 51,000.
Regarding
As
the-
regard that
that is the money,
interest,
that is the GST
As
deduction.
regards the interest, now pursuant to the order passed by this court on 27/10/2025,
GST return.
insofar as the interest aspect is concerned, it has been submitted that the PWD, the PWD, the respondent authorities are taking effective steps for finalizing the said amount. And most likely the said amount would be paid within the second week of December 2025. Taking into account the above listed matter on 10th of December, on 12th of December for an update. In the meantime, Mr. Daria, you
Yes.
pay that because there should not be further more amount.
What-
And
Obliged.
this court shall further consider that it will in line to logai rakha. This affidavit in respect to the as sought for by the order date affidavit as sought for by order dated 24/9/2025, however, have not been filed by the respondent number 4. So under such circumstances, the said affidavit be filed on or before the next.
Obliged.
I will only close it once because this line is necessary for urgent. Not for me, but for your benefit.
Obliged.
My lord, in this case, last week they have filed an affidavit. I want to file reply matter.
What? They are appearing for contempt matters also, Mr.
My lord, because,
What is wrong?
no, wrong is my.
You are not asking your juniors to appear for contempt matters? Senior advocates appearing for contempt matter.
They are, my lord, facing lots of trouble, my lord. Those contractor, they are not getting, my lord, they are due so many years, my lord. How they will survive, my lord? Your lordship kindly see.
Affidavit filed.
File last week, they have filed, I want to file reply.
The petitioner would like to file a reply to the affidavit filed by the respondents. Who's taking into account the above, list this matter on 8th of December 2025. In the meantime, the affidavit reply be filed on or before 3rd of December.
Next one the same, my lord.
Okay.
Better than my affidavit.
ठीक है कोई को नहीं की तो
Well, respondent number one was supposed to file their affidavit.
Lordship, we have instruction to appeal in this matter, but we have no filer and wakalat nama yet. Lordship, can it be taken up on some other day? Because on the last occasion, Mr. asked for our director obtain instruction matter.
when Bihar election is over.
Yes, your lordship. Any day, comment, your lordship. Any day.
Tomorrow?
Not.
Okay, list this matter on 1st of December 2025. The respondent number one shall file the affidavit without fail on or before the next occasion.
Yep.
Next thing. Yes, Mr. Burwa, what is it?
My lord, notice was issued as far back as on 28/10/2024. Till now, they have not filed any affidavit. In fact, my lord, this is a tender matter pertaining to Nagaon Medical College, my lord.
Oh, there's a stay.
There was a stay, my lord.
No,
On 28/10, there was a stay.
Then what happened?
Then, my lord, on 4/4/2025, the status quo was given, my lord, on 28/10/2024. They violate the court's order. The state respondents and private respondents, they enter into an agreement on the very next day. And my lord, on 4/4/2024-25, when the matter comes, they don't apprise this court. That is exactly what they have done, my lord. May I just point out, if your lordship kindly takes up the.
No, why the matter has come up?
My lord, this
There's
has,
an I.
that I has already been disposed of, my lord.
Now what remains?
Now,
They are not filing affidavit.
We have to file affidavit.
they are not filing any affidavit since last 1 year, my lord.
Oh,
On the last occasion. only
on
we
the
have to
ground
appear.
of non-travelers we discussed. it. What is your relief? Writ of certiorari to set aside the decision of the year to award the work contract in year. Okay, we set aside this appointment.
Which we
Okay,
have
respondent number
appeared
five.
on 17/9.
Huh?
This case, I'm for the respondent number 5, private respondent. We appeared in this case on 17/9/25.
So what?
And filed in this case, lordship.
How does it matter? You have not brought your stand.
In this case, we have brought.
No. I think we set aside.
We may be allowed to, no, lordship.
No, we set
No,
aside.
lordship. In view of that order, lordship, in the this case.
Page 78 makes it clear, my lord.
We set aside this.
Page 78 makes it absolutely clear. On the next day itself, they knew.
May fix it for.
They play hide and seek with the court.
No, we set aside this. Intimation regarding court's order relating to status. quo.
Page 78.
Status quo order being given.
They knew on 29/10 itself.
Set aside. Agreement entered on 1st of year.
1st of November, my lord.
After the
Page
order
80.
being given. Okay.
Lordship, kindly allow me.
Despite status quo order.
You are appearing. Why you are violating the court's order? Mr. Bora, why you have not also filed your affidavit? These type of matters, can you go put in for 1 year?
There was a status quo order, so my lord, there was a status quo order and person state order, my lord, that was notified. The respondent authorities were given liberty to manage the dietary article supply by engaging some other. So accordingly, the college authorities engaged some third party and they were managing the supply of dietary articles. In the meantime, thereafter, the private respondent has filed a case saying to take a notification of their status. And then it status order has been last week.
So you have not granted. After the status quo has been vacated, then only you have granted the contract to the private respondent.
Yes.
Not prior to that.
No, Lordship, work order was issued most earlier. Before.
Did you pass an order that you are not giving effect to?
Lordship.
Hello, we do one thing. We have not filed an affidavit, not necessary. We set aside this on today is the 15th.
Lordship,
On
to time
13th.
given,
30.
Let there be unlucky day for them. We'll have it on 13th.
Okay.
It is seen that no affidavit has been filed on behalf of the respondents in spite of they have put in the appearance as far back in the month of September 2025. Mr. A.K. Burwa submits that submits that there is urgency in the instant proceedings. Considering the above, this matter on 20/11/2025 for final disposal at 2 p.m. If the respondent, however, are given a final opportunity to file their reply on or before 18th of November 2025.
Obliged.
Failing which, the petition shall be decided on the basis of doctrine of non-prevalence.
Obliged.
Yes, Bokazan Cement,
Come here, Lordship.
what is this?
Lordship, the delay may be condoned and restoration application for WPC 7614 maybe.
We filed our objection, my lord, for the delay and the condonation.
How much delay?
My lord, as per them, 168 days delay, but
158
is-
days for what?
my lord,
For what?
for
Okay.
filing restoration application.
Huh?
Forest, Lordship, actually it is, the delay is 284 days
No, wait, what did you file?
for restoration.
Dismissed?
No.
It was dismissed for default.
Yes,
You filed a restoration. Why was it dismissed for default?
Lordship, the council who was engaged, original council, LP Sharma, he expired, Lordship.
Oh. Chalo. This should be restored.
There are, my lord, earlier instances also, it was dismissed for default, my lord.
Huh?
Earlier, expiry order passed in 2013. That was, but then that was restored. And my lord, now they are asking for reducing evidence of 2009, my lord. And the petitioner
No,
who.
whether they are entitled to as per the petition, petition or not, that is another thing.
Yes,
Don't
but
you think-
the union which was representing that union is become ineffective, my lord. That's no more functioning. And there are other two unions which is functioning. I've stated in my objection, my lord, everything, my lord.
But that cannot be a ground for not condoning the delay.
Where there is.
That's on merit.
Where there is authorization or not, that is also been very doubtful, my lord.
We will argue on that on merits, don't you think so? Or is it that his case is so strong that even the might of Mr. J. Roy cannot stop it? Something like that. Huh?
Then I'll leave it to lordship.
Okay. This is an application for condonation of, so both the applications are taken up together for disposal. Taking into account that one is an application for condoning the delay in filing the restoration application and the other application has been filed for restoration. The grounds and reasons stated in both the applications are one and the same. In as much as the petitioner union, the applicant union were not apprised about the dismissal of the case, isn't it?
Yes.
On account of the death of the council, who were council namely late LP Sharma, who was actually conducting the matter. Taking into account the reasons so assigned in both the application, this court condones the delay. Now, is of the opinion that the application seeking condonation is required to be this court does not find there to be any delay or laches on the part of the petitioner applicant. And further, the grounds and reasons are good grounds for restoring the accompanying writ petition. Accordingly, in the accompanying writ petition, being WPC number 7614/2017 is restored to the file. Full stop. IA stands disposal. Full stop. Before that, disposal, before parting with the records, this court, however, observes that the contentions so made by the learned senior counsel appearing on behalf of the Bokajan
Cement factory.
cement factory in respect to the locus of the applicant as of now, taking into account that the locus of the applicant as of now to continue to agitate the grievances of the workmen shall be considered at the time of hearing of the accompanying writ petition. Full stop. Yeah, Lord. In view of the orders so passed in so and so, the instant writ petition is restored to the file. And main petitioner, full stop. Liberty given to the Bokajan Cement Company, factory company,
Factory. Cement factory.
company, it's a
It's Cement Corporation of India.
corporation, the Cement Corporation of India to file additional pleadings in view of the subsequent developments after the dismissal of the instant petition on 7/8/2024. To list this matter on 2nd of December 2025 at 2 p.m. for final disposal.
Okay.
Right? Oh, dismissed. Dismissed. 46, dismissed. 46. Dismissed.
7.
Miss Vijay Lordship, this review petition Lordship regarding cross of PW1 Lordship.
You are paying for somebody?
They appeared and filed their objection Lordship.
Well, leave this matter on 18th of November 2025 at 2 p.m. for final disposal.
Lordship, interim was there Lordship.
Interim order passed. Earlier shall continue till the
Obliged Lordship.
Yes, what is this?
My lord, my lord, I am the headmaster of Navadiganta ME School.
What am I doing with this matter?
My lord, here at the time of sending particulars of the teachers for provisionalization, the name of the respondent number 6 was not enlisted there.
Understood,
So-
but
so-
why? Oh, no, but Mr. Why am I taking up this matter? This is an order passed by whom?
No, that, my lord, it just, Mr. I'm Buzurur.
But can I take up this matter?
Yes,
Because
yes.
this doesn't appear to be a bench 4 matter.
I don't have one for that. Bench two meta matter. Bench two.
So my lord, cases like this, at the time of sending particulars, I did not send the
Mr.
name of.
Mahmood, I have all indications to, means all the open aspirations to take up your matter, but the fact that I am bound that this matter is not my cup of tea. Taking into account that this matter, the instant petition, the review petition has been filed against an order passed in
In
registry
IN number,
number 57 25/2021 arising out of WPC number 5725/. That's both are same.
No, whatever was passed in IA, that is IA
what
number
is the
358.
Huh?
IA number, kindly see page 16.
IA number
358,
2022
22 arising out of,
out of WPC number 5725/.
Yes, yes.
2021 by his lordships.
my lord, I
Othinka
AM Buzurg.
Mullah Buzar Borua, J, as his lordship then was, by Othinka Mullah Buzar Borua, J, bracket J, as his lordships then were. And this court having is not presently taking up a bench, is not being assigned with bench 2 roster. The registry is directed to list the present review application before the bench, who is presently taking up the roster bench 2 roster. List accordingly on.
Short date. I am not getting salary, that is why, my lord.
Okay. List the matter again on 14th of November 2025
Publish.
before the appropriate. 49.
Yes, my lord. I'm seeking review of the order dated, my lord.
49.
Yes, my lord.
What is this? What has happened?
I'm seeking a review of the order dated, my lord, 23/20.
Purnima Deka?
Yes, my lord. This is a bench, this is a bench 2 matter, my lord.
Huh?
This is a bench 2 matter, my lord.
No, this I can take it up because this is my judge.
Yes, my lord.
Why are you asking for Purnima Deka?
Only ground for seeking review, my lord. This Purnima Deka was, judgment was passed on the basis of an judgment passed in a writ appeal, my lord, taking into account that the facts are similar. No.
What? Where is my order?
Page 138, my lord. 137 is the Annexure B, 138, the relevant portion, my lord. And my lord will find the relevant paragraph, page 148, from paragraph 8 to 11, my lord.
What is this? What is the direct?
Direction was to give the area salary for a particular period where the petitioner was terminated on that period, my lord.
Taking into account the submission to the learning council as well as also from present discourse of the director secretary to verify now is similarly situated with the appellant in Wikipedia. If it is found that the petitioner is similarly situated, the directors will be directed to take the. Okay, then what is wrong?
Otherwise, petitioner is similarly situated. But only thing is that, my lord, that the person preferred the writ appeal, Dipali Bormon, she approached this honorable court in the year 2015. The order was passed in the year 2014. She immediately approached. But this particular petitioner, Purnima Deka, she approached only in the year 2023. So there was a delay and lapses on her part. That was not considered.
You did not argue. Heard Mr. N.J. Khatonia, the learned counsel, appearing on behalf of the petitioner. Good stuff. This is an application seeking review of the judgment and order dated 23/2023, passed in WPC number 1548/2023, whereby this court specifically directed that whereby this court, taking into account the judgment of the learned division bench of this court dated 23/9/2022, passed in writ appeal number 211/2019, directed the Director of Secondary Education Assam to verify as to whether the petitioner the respondent herein was familiarly situated with the appellant in writ appeal number 211/2019, and if upon verification it was found that the respondent herein the petitioner the respondent hearing is similarly situated, the Director of Secondary Education Assam was directed to take necessary steps to release the area salary of the petitioner respondent hearing for the period from 21/5/2012 to 18/1/2014, and to make payment of the area salary to the petitioner the respondent hearing. This court further directed the said amount be also released within a period of 3 months from the date a certified the said exercise be completed within a period of 3 months from the date a certified copy of the order is served upon the Director of Secondary Education. It has been submitted by Mr. N.J. Khatonia, the learned counsel appearing on behalf of the state of Assam, that the verification was carried out and it was found that the petitioner oblique the respondent herein was similarly situated with the appellant in WPC Read Appeal number 211/2019. And therefore, but the petitioner oblique the respondent herein have approached this court
After 9 years.
after a long delay. Full stop. It is the opinion of this court that the said grounds and reasons, the said grounds were not taken up when the writ petition was decided by this court. And it is for the first time in order to deny the petition, the respondent herein the benefits of the order dated 23/2023 passed in WPC number 1548/2023, such a attempt is being made by filing the present writ petition. Accordingly, a review application. Accordingly, this court not only dismisses the instant review application, but also directs the payment of interest at a rate of 18% per annum be paid by the state of Assam, the dues payable to the respondent herein for the period from 21/5/2012 to 18/1/2014. This court further directs that the said amount be recovered from the salary of the Director of School Education,
No, the Director of Secondary Education.
the Director of Secondary Education, on account of his failure to comply with the order passed by the school.
Regarding interest part,
18%.
May payment,
This is absolutely not called for. Why have you moved this matter after 2 years? After carrying out the verification, do you have the audacity to file this type of capital? Is this bona fide on your part if you have not made the payment? The direction was to be made within 3 months.
Yes.
Then I think should ask the chief to give me this bench 2 matters. The Director of Secondary and all these education departments have taken for people for a spin.
No,
The order was passed by the division bench in the year 2022.
Yes.
You did not take a stand as regards that the petitioner was a fence sitter at that point of time when the directions were passed. Then after that, after 3 years, you are filing this and you deny him.
it was filed in the year 2025 only, my lord, not 3 years.
Then-
But still, anyway, my lord, there are delay in our part also approaching.
Then
But my lord, regarding my interest part, my lord,
this court does not find this court finds that the instant application appears to be not bona fide and have also and files not bona fide. This court finds that no grounds of review have been made out. Apart from that, this court also finds that the application to be not bona fide. The conduct of the appellants, the review applicants is reprimanded. Accordingly, this court dismisses the instant review petition. Interest to that.
obliged.
Item 50.
Yes, what is this?
I please your lordship, this is a contempt proceeding lordship.
As regards the process is ongoing. Anything?
Worship here, we have paid the bill. Petitioner.
Payment?
The Worship, we have made
But still we have to receive 2 lakhs for it.
that payment.
Done. They have done completely. Some small amount was, small amount remains unpaid. But today I have come to know that they have already paid it.
It has been submitted with that the petitioner have received all the payment to which have they received all the payment? Has the petitioner received all the payment? Huh?
Credited to the account of the petitioner.
That is what I am saying. It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner have received the payments.
Actually, Lordship, my client is outside the state. So today I contacted him. He told me that till now I have not received 2,42,000. So that was his version. But as per
2,42,000, we had received the ceiling proposal and we have given our sanction. So most probably that might have also been released. The amount which might have been affected.
2,36,000. Treasury payment received. You are being given 2,36,000.
Lord,
Not 2,40,000. I think some amount has been deducted towards this.
that is a TDS deducted.
The total deduction is 6,000.
Yes, loss.
It has been submitted that the petitioner have been paid his dues in terms with the directions passed by this court dated 16/12/2024 in WPC number 3659/2024. Accordingly, that nothing further remains in the instant contempt petition for which the contempt proceedings stands dropped. The details of payment as have been provided to this court by Mr. So-and-so, representing the respondent number 1,
2 and 3.
2 and 3 is kept on record and marked with the letter X.
Obliged. Lordship.
Yes,
Yes, Lord, contempt proceeding, Lordship. Notice may be issued to the new incumbents, Lordship. Newly impeded incumbents, Lordship, notice may be issued.
and
We have already filed an IA, Lordship, that was disposed of on 24/10/2025, Lordship.
Mr. Gusami, you are appearing for them?
Lordship,
Then your namesake,
Lordship.
isn't he? Same? Huh?
I mean,
The director of animal husbandry is your same name?
yes.
Okay, so are you filing the affidavit?
Regarding the earlier, I will file it.
No, have you got that order as regards 2 and 3?
Regarding
The directions
they
were
already
passed?
Lordship, earlier contempt, not Lordship. Earlier contempt, I will file, Lordship. It is prepared, Lordship.
But this note have passed an order, what is the direction passed? No modification of the criteria for so and so the impugn AI to cancel the tender to go for fresh tender as result is arbitrary. Initiated by AI ahead of the AI is resolved to be satisfied and this court are directed to bring the tender process initiated to a logical conclusion as per the terms of the NIT dated so. What have you done?
Lordship, we took a decision, Lordship, and sent for approval to the principal secretary, Lordship. It is the person of the contender 1, Lordship. It is Mr. Deuri, Lordship, earlier director. Now he is not in the office of the director, Lordship. New directors comes and the petitioner filed an IA for implement the new director and the principal secretary, Lordship. It's a commissioner secretary, Lordship. And that was allowed, Lordship.
That I have allowed. Then
Yes. Now, Lordship, so far regarding the earlier contempt, Lordship, it is one.
that is okay. Now what have you done?
Yes, I have to take the instruction, Lordship.
Why is it taking such a long time?
Lordship, the
2025.
notice
Okay.
was not issued,
2 weeks time.
Notice
it.
was, notice,
In whatever maybe, 2 weeks.
Lordship, 2 weeks.
You see, the order has to be complied with.
Yes,
We are not
Lordship,
concerned with all this thing.
Lordship.
Okay, this matter on 28th of November 2025. In the meantime, Mr. J.K. Goswami appearing on behalf of the respondent number 2 and 3 shall apprise as to whether the judgment passed by this court dated 4/2/2025 in WPC number 3832/2024 has been duly complied with or not. And if so, full stop. It is further observed and directed that in the circumstance the said order have not been complied, judgment had not been complied, the reasons therefore.
In 4P is required.
T2.
May it please your lordship. Lordship, respondent has not filed an affidavit.
Affidavit filed. No affidavit filed, na?
Yes, sir.
Oh, affidavit has been filed. Affidavit of Dusty filed, huh? Okay. Oh, this matter.
Yes, sir.
Okay. It is seen that all the respondents have duly appeared. It is seen that the service upon all the respondents are complete. As it appeared from the affidavit of service and the appearance of counsels in respect to the other respondents. Accordingly, list this matter on 19th of November 2025 for admission. Interim order passed earlier shall continue till the disposal. This is already there.
62.
May it please your lordship, Mr. Pranjal Sharma is indisposed and the affidavit hasn't been filed. Mr. Pranjal Sharma, he's indisposed, your lordship, so the affidavit is also hasn't been filed.
No affidavit filed on behalf of respondent.
Yes, your lordship.
List this matter again on 8th of December 2025. In the meantime, the respondents shall file their
Yes, your lordship, 15th or 8th, your lordship, the date.
8.
Obliged.
Please, lordship matter is pertaining to tender lordship. We have taken the steps also. And we have filed a dusty also, lordship.
Okay.
Affidavit for dusty.
Service upon the respondent, number 7, is complete, taking into account the affidavit of service so filed by the petitioner. Full stop. Taking into account that all the service upon all the respondents are duly complete, list this matter for admission on. We have passed an interim order.
Yes,
Huh?
yes, lord.
Passed on 8th of December 2025. The interim order passed on 1/8/2025. Shall continue till the next day.
64.
Lordship, dusty affidavit has been filed on.
Service complete?
Yes, Lordship.
You are paying for respond number?
6.
6, huh? Okay. The service being complete, list this matter for admission on 8th of December 10th of December 2025. The respondents shall bring on record their stand by filing the affidavit on or before the next date. On or before 3rd of December 2025. So the interim order passed earlier on 25/9/2025 shall continue till the next day.
Nice, Lord.